We'll call to order the meeting of the Haverford Township Zoning Hearing Board of Thursday, August 21st, 2025. Present at the front table to my far left, Ed McGargy, a voting member. Dan, what's your last name? Van Wyck. Dan Van Wyck, our solicitor this evening. To my right, Bill Rhodes, voting member. Jesse Poynton, a voting member.
Good evening.
Jonathan Mount, the zoning officer. Good evening. And I'm Robert Kane, I'm a voting member and the chairman. We have some new cases tonight and some continued cases. We're not going to go in the order of the agenda. The first case will be, before we begin, I almost forgot a very important part. Billy, would you please lead us in the pledge?
Please rise and repeat after me. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first case will be Z25-24 Murphy O'Connor LLC, owner of 300 Westchester Pike, doing business as the Yard Pub, Haverford Town, PA, DC number 2202-012-8100 and 2202-012-8101, who seek the following relief from the Zoning Hearing Board: appeal the determination of the zoning officer in his letter of April 30th, 2025, relating to amplified music, outdoor dining, a second dining tent, and portable heating devices with an open flame, that the owner is in violation of Zoning Hearing Board Decision Z2212, that the owners are in violation of, and an alternative seek variances from Section 182-731A4 related to amplified outdoor music and outdoor dining, and Section 182-731A3 limiting outdoor dining to 7 a.m. to 9 p.m., where the restaurant adjoins a residential use, and a variance from Section 182-902B requiring a permit for the proposed erection of the second tent, and a variance from Section 182-731A10 to allow the use of a portable heating device with an open flame. The property is zoned C1 and located in the 9th Ward. Wow, that's a mouthful. All right, where's the applicant?
Good evening.
Good evening.
I'm Daniel Koval. I'm an attorney. I represent the applicant. I'd like to make an opening and then put on some testimony of two witnesses and introduce exhibits.
Okay, Dan.
Thank you. So I represent Murphy.
Before we begin, I just want to ask, are you going to enter?
Belcher on behalf of the township. I'm here to defend the notice of violation. It's my understanding that the notice of violation portion would proceed first, and then any testimony regarding the variances would come after that.
And you're going to request party status, right?
Yes, on behalf of the township.
Okay, and do you have any objection to party status?
I don't.
Any discussion from the board? All right, the township's granted party status. I'm not quite sure. I'm going to let the applicant proceed with the case in the order that he chooses, but and then you can address whatever issues you want to address in the order that you choose.
Okay,
Yeah,
sure.
I don't know how we can separate the two out and from the other relief we request, so I would just go straight forward with the witnesses.
Can I ask you a question
Sure.
then? Would one way tease it out be that notice of violations for things that were not relevant to our 2022 decision, for which that's essentially a new case, right, for you? We've never ruled on things like the open flame, the second tent. They weren't part of the original request. Would that be a way that we could distinguish some of these things?
Well, the open flame, I don't think we're really going to need to address that. I don't think we need relief on that. And
So you're withdrawing the request for relief?
yeah,
on that?
I think so. And I'll explain what we have. And again, some of that depends on the testimony, because there is a heating unit for the tents, but it's not an open flame. It's a system that's designed for it. And then on the second issue, the second tent, we would address that through the testimony, which is really kind of intermingled with the rest of it. But as you said, we're looking at three things here. We're looking at a request to extend or to allow the use of amplified music or sound to 11 o'clock on Saturdays and Fridays and Saturdays, and to 9 o'clock during the week. And our contention on that is that because there's been a change in the law, it actually happened 3 days after the decision in the last case. The liquor code was amended, and the section is 4-493.1, parens E, close parens 1, to allow licensees to have amplified sound, music or other sound, outside, up to 75 decibels at the property line. So that's really a request for a change in the condition from the prior application. We also seek a change in the condition to allow the operation from, instead of from 7 a.m. to 9 p.m., to extend that to 11 p.m. on Friday and Saturday, to allow service outside and the use of the outside area to 11 p.m. Whether that's a separate application, a new application, or a change in condition really depends on both. We phrase it as a change in condition and also a variance application. And an application, really, our contention here is that the ordinance does not, in this case, should not be interpreted to prohibit service to 11 p.m. The ordinance allows service to 11 p.m. for outside, but restricts it to 9 p.m. if the restaurant adjoins a residential use. And in this case, and this is going to be testimony, but the property is a large property. It's surrounded on 3 sides by commercial zoning. There are houses, or there is a house that's about 200 feet from this, from the outside service area. So the question
The
is,
house or a residential property line?
the residential property line is a little bit closer. It's probably about 150 feet. But you go to the property line, there's Nailers Run, there's an easement, I believe, for a sewer line, there's woods, and then it says the residential use. So is the residential use the property line, or is the residential use the house?
Who owns Nailers Run and who owns the easement?
The easement, I believe, is a sewer easement, but it's part of the property. It's part of
And it's
the,
not an easement. An easement would be an encumbrance over
well,
property owned by a third party.
I'm assuming it's a sewer easement. It's shown on the plan as a sewer
So who
easement.
owns that land?
I would imagine that the sewer authority owns it or the township.
And I don't think there would be an easement.
Okay, well, regardless of that, the property line, the plan shows where the property line is and where the service area is. It does not show the house, but our contention is that this restaurant does not adjoin a residential use. And the alternative, we would ask for a variance. So there's a variance component to that.
And counsel, if I may, just for clarification, obviously you're asking for variance on the time, but you also mentioned a change in code, is that,
There's been a change in the liquor law.
okay.
Yeah.
You're not asking
Our-
anything changing as far as ordinance?
Not for the Haverford Township ordinance. Our contention is that the change in the liquor law preempts the Haverford ordinance.
So let's talk about
Let
this
him
right
make
now.
the-
Yeah, go ahead. You want to explain
his
your
argument.
theory of preemption?
Sure. When the applicant came to this board back in July of 2022, they asked for relief and were granted relief to operate outside, but the ordinance, the Haverford Township Code, prohibits the use of amplified music outside. The order came down on July 8th. On July 11th, the liquor code was amended to allow for the use of amplified music, amplified sound outside for liquor licensees. And I'm going to try to find the code section here. But the liquor code was amended to say, notwithstanding any other provision of law to the contrary, except as contained under paragraph 3, the holder of a license under this act located in a class 2A through 8 county, Delaware County is a 2A county, may use or permit to be used inside or outside of the licensed premises a loudspeaker or similar device where the sound of music or other entertainment or the advertisement thereof does not exceed 75 decibels beyond the licensee's property line. And it goes further to say, the Bureau of Liquor Control Enforcement of the Pennsylvania State Police shall enforce the provisions of this subsection.
Right, so you mentioned the clause, except as provided under paragraph 3. Why don't you read that?
Okay, so paragraph 3 says, nothing in this section may be construed to limit the rights of a municipality under subsection A. And subsection A says, nothing in this act shall be construed to preempt the right of any municipality to regulate zoning and enforce any other local ordinances and codes dealing with health and welfare issues. So, because the liquor law specifically regulates the use of amplified sound outside for licensees, it preempts that aspect. It doesn't preempt the township from having a law that says, well, we limit the time outside that you can use, that you can serve outside, or here's what you have to do in terms of complying with the code, here's how many people you can have, and all those other things. But with respect to amplified music, the liquor code preempts the township's ordinance. That's our argument.
And so couldn't you read it that paragraph 5, I think it was, or clause 5, gives the Bureau of Liquor Control Enforcement the right to enforce the provisions of this provision, of this section. But it doesn't say that the township can't enforce its own local ordinances.
I disagree with that,
Okay,
because
so
once
you'll have to submit a legal brief.
I'm happy to do that.
Okay.
And I anticipated that, though I don't have one tonight. So I will submit a legal brief, and it's a preemption issue. And it's similar to a zoning code cannot limit the hours of the hours that a licensee can serve liquor. That's within the purview of the liquor law.
So why is clause A in this section?
Because, in my opinion, Clause A means just what I said. Even though this particular aspect of operating outside is preempted, because it allows a licensee to have amplified music outside, the rest of, and other aspects of regulation of outside use is not preempted.
So you don't think that the reference to paragraph 3 and the provision of paragraph 3 that cross-references to A would bring A right back into this section?
No, because otherwise it would render it a nullity. It would say, well, licensees can operate outside until, can use amplified music outside until the hours set forth in the ordinance. But we'll allow the townships, or we'll allow the municipalities to not allow that. So what would be the point of putting that in the liquor law?
Say that the state says that you're allowed subject to local ordinance.
I disagree. I think it's a preemption issue, and there are cases that address it. I cite some.
So look at the cases in your
Right.
brief.
Got it. All right.
Go ahead, Dan, with your-
All right, so that's the introduction here, and you've brought out all the issues. So 3 things we're asking for here. One is to be allowed to operate outside until 11 p.m. on Fridays and Saturdays. And the argument is that it's not, the residential property doesn't adjoin the restaurant, number 1. Number 2, in the alternative, it should be a variance, and you can hear testimony to that issue. The second point is that my client should be allowed to use amplified music to 11 o'clock, and actually the liquor code says 12 o'clock, but 11 o'clock Friday and Saturday, and 9 o'clock during the week, and that's because of the change in the liquor code that preempts the township's ordinance. The third issue has to do with the second tent. My clients put up a second tent. It wasn't something that was permitted in the original approval, and they've done it. We'd ask for approval of that. They're fully prepared to file any applications for permits and do all that to run that, to have that permitted. And again, we request, the argument with respect to the third tent, with the second tent, is there's nothing in the code that specifically prohibits it. So it's really a question of applying for a permit, which we didn't do.
Yeah.
And I'm remiss in failing to advise my client to do that. So we could also, while we're waiting for the brief, we could also file for a permit and then have a hearing on have that denied by the township and then have a hearing on that issue. Maybe that's better procedurally, but
And why did the applicant think they could put up a second tent after going through the 2022 case where we discussed the tent ad nauseum?
yeah, we'll have testimony on that. I mean, they basically put it up for one event, and the person, you'll hear testimony to that issue.
And has the tent that was approved, has it ever come down? Has either tent come down since they've been put up?
I don't believe so, no. But the witnesses are here, and you can ask them those questions.
Are you prepared to show additional parking for the second tent?
I don't think we need additional parking because the area was already used for outside service. It was undedicated to parking, but we're prepared to show that we have the required parking. We have analysis on that.
I apologize. I didn't.
Oops, that's all.
Clear the room. I didn't get your
My name, Kaylee Melcher.
name. Kaylee?
Kaylee, Kailie. Melcher, Melchior. And if I may, just based on what was described, it sounds like some of the portions of the notice of violation are no longer contested. Specifically, that the tent does not have a permit, and that the outdoor, and that the open flame is an issue. So is your client no longer appealing those parts? Or I just want to, if we can clarify that now,
Yeah,
we resolve those.
To the extent, and I believe and as I said, I'm remiss because the notice required my client to apply for a permit and they didn't do it. And we're fully prepared to do that. And I think the procedure would be that we apply for the permit. If it's granted, there's no issue. If it's denied, we come back here on another day to do that. So that's our position with respect to the tent. And ultimately, if it's denied, then we'd also request a variance for the tent.
You do want to proceed with alternative relief, assuming that the permit might be denied.
That's correct, yes.
The township is here to defend the issues in the notice of violation and not to specifically take a position on any of the variance requests.
Sorry, Joe.
Only to state at this time that, that there is adequate support that the notice of violation was properly issued and that all of the things were observed by the zoning officer and were in violation of either the prior decision or various portions of the zoning code. As far as what the plans are that are to be presented tonight, I would ask that we be able to hear some of them and then submit legal briefs, keep the record open, and potentially the township may have further questions. They are not at this time aware of what things are being proposed because we're essentially here right now to just defend the.
So you're asking that the record be left open
Yes,
at the end of the
at the end
hearing?
of tonight's hearing.
Okay.
I have no objection to that. I think we'll end up requiring that regardless.
Okay. Then, Dan?
Thank you.
Proceed.
Yeah, how do you want me to have the witness come up here? Is that how you
Yes.
do it? All right.
And if you want to stand over there to ask your questions, that's typically what
Yeah,
people do.
I'm gonna bring up Ward.
Yeah, those mics are on, okay. Yep.
You guys,
How you doing?
how are we? Just give me a minute. Also gonna hand up our exhibits.
Is there a reason that the application didn't include any plans at all?
We did not have plans at that time.
You know what, I'm going to share with you, Bill, let me get this. Okay, yep. So this is P is the sequence. This would be P3.
Yeah, I think so.
Well, we'll wait for Dan to identify all those exhibits, but it's Dan. Thank you. You're not going to identify their exhibits for them.
Tell the panel.
What's that?
Tell the panel your name, please.
My name's Tom Rafferty. I'm a co-owner of the Your Pub. Tom Rafferty.
No. Tom, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name, I'm sorry to make you repeat it, and the capacity in which you appear?
Thomas J. Rafferty, co-owner.
Tom, you're the co-owner of the Yard Pub,
Yes.
and the Yard Pub operates, the actual name of the entity is Murphy O'Connor LLC,
Yes.
and there's a liquor license also,
Yes.
and the owner of the liquor license is 300 West Chester Ring, is that correct?
Yes.
How long have you been involved with this pub? How long have you run?
For 5 years.
And before the pub was called the Yard Pub, it was also called Tip O'Leary's, was that the prior name?
Correct.
Okay, so this plan is Tip O'Leary's, but we'll discuss it in a minute. I'm going to show you exhibit E3, which is a plot plan, and ask you first of all, have you looked at this plan?
Yes.
Okay, and does this plan reflect the improvements on the property as they exist today?
Yes.
Plan notes that the size of the lot is 1.18 acres. Is that consistent?
Yes.
Have there been any, aside from the tents that we've shown on this plan, have there been any improvements to the property since this plan was prepared in 2000?
The exterior bathrooms.
Sorry?
The bathrooms.
Okay, so where are the bathrooms?
Bathrooms.
The exterior bathrooms. Sorry. There you go.
Okay, thanks. Is there a second microphone? I'm just going to hold this. Tom, with respect to the property, we have the main building, correct?
Yes.
Okay, and what's in the building? It's the bar and what else?
Or kitchen, bathrooms. There's a party room as well on the side there.
Okay, and there's a patio that's outside?
Correct. Yes.
Okay, and how long has that patio been in existence?
Since 2000, I think 11.
And how do people access? How do they come onto the property? Where's the entrance?
Up there to the right here, off Westchester Pike.
Is that the only entrance and exit from the property?
Yes.
Now, with respect to the uses that are around the property, what uses are to the north?
There's a storage facility and a medical center.
Is that across Westchester Pike?
Yes.
Okay, what uses to the east?
You get Kohl's and Lowe's.
It's a commercial use.
Yes. Yes.
And there's a use to the south or something to the south. What's the,
That's the giant Chipotle little shopping center there, gas station.
all right, is there are there any residences that are near the property?
The only residence would be in this section over here.
Okay, now, there's an area shown as R6, which represents its own classification. Can you point out the closest house to this property, to your property?
Probably right about here.
Okay, and you're indicating below the R6. Did you measure the distance from the tent to that?
That's 200 feet.
200 feet to what?
200 feet to the house. I mean, I didn't go to the
And
property.
again, why are we focusing on the location of the house on a residential property?
Because I think it says a residential use, it doesn't say
Yeah.
residential property.
As residential district.
No, it doesn't.
You look up the residential.
Do you contend that somebody at the back of their property is not a residential use, all the way up to their property line?
I think there's an ambiguity and it has to be interpreted in favor of the applicant.
I don't see how there could possibly be an ambiguity between somebody in their property using a residential use. I mean, that's preposterous.
We're going to take a 5-minute recess, then you could get your easel set up. Off the record, Jeff? Go ahead, Dan.
Thank you. Mr. Rafferty, Board asked why you put up the second tent when it wasn't part of the application previously. What happened? Explain it.
After the first zoning hearing we had, right shortly after that, the state came out with the Outside Dining Act because of COVID, and the bar industry got crushed. So when that happened, I filed an appeal to the decision here, and we never got that appeal. No information was sent. I did file the appeal through another attorney friend of mine, and we did contact the township 3 times, saying where we at, and this was going on a year. So I finally called my attorney and said, "What's going on with the appeal?" And he just said, "With this new dining act," now I went off the council's advice, because I would never, we would never just start up doing things, against the township, saying, with your decisions. I wanted to make that perfectly clear. We didn't just say, "Hey, the board," we just. My attorney told me about the act that passed, said you're legally allowed to have it as long as the decibels don't go, higher to a certain level. And the tent issue, we had that for, believe it or not, this is a true story. The tent guy put the tent up for St. Patty's Day. It's a big day down there, so the weather was inclement, so we had it. And he disappeared for literally 2 months. The tent guy who put the tent up, Kelly was calling him, and we did leave it up, so I was saying we are at fault for that. I mean, but for 2 months.
And has it ever been taken down?
It was never up. That was only up last year at St. Patrick's Day.
Have you taken it down since?
No, have not. No, it's still there. It's March.
And the appeal that you filed is attached to the application, was at CV 2022-005694, is that correct?
Yes,
And you signed that as
yes.
and that's still out there, but it hasn't gone anywhere.
We never got the appeal. The information never got sent to me for us to have an appeal on this.
Now, I'm going to go back to testimony about the use. So the property location of the tents are shown on that plan. Is that accurate?
Yes.
Okay, and what are the size of each of them?
40 by 30 and 40 by 30.
Okay, did you measure the tents
Yes.
for this hearing? All right, and I'm going to ask you, for the record, to look at applicant's exhibit 3, which is a Google map. Is that an overhead shot of the yard pub and the surrounding area?
Yes.
Okay, and that shows the homes that are on Olympic
Yes.
Avenue, correct?
Yes.
Okay, thank
Yeah, what exhibit was that?
you. That was A3. I'm sorry.
P3?
P4, sorry.
It's P4.
Now,
The site plan is 3.
site plan is 3.
Okay.
I do, yes. Excuse me.
Yep.
You have a set right there.
Yeah.
I'm going to show you some photographs of the property. We've looked at these before. This is P5 photograph number 1. And does that photograph show the front of the establishment?
Yes.
Okay, the tents are to the left in this photograph?
Yes.
The east. And is there a fence between the tented area and the sidewalk?
Yes.
That was the fence that you applied for and received a variance to put up with the last appeal, is that correct?
Yes.
I'm going to show you a photograph.
Dan, one quick question. In the photograph you just referenced, what's the green section? Is that just a different color fence? You see what I'm talking about?
I think he's referring to this.
Oh, that's a sign. Yep.
Okay.
Oh, okay. Yep.
I'm going to ask you to look at photograph P52. What does that photograph show?
The back of the tent from the parking lot, back parking lot.
So would you point the direction that the...
From here, look it up.
So that would be tent number 1, and tent number 2 is adjoining it, correct?
Correct. Yes.
And underneath that area, there's AstroTurf.
Yes.
How long has the AstroTurf been there?
Since we had the first meeting, I guess in 2000, what year was it? Yeah.
Sorry, can you, yeah, you have to speak in the microphone. So
I know,
how
come
long,
up, it's a little
there
loud.
are, the AstroTurf that's there, both, under both tents was there since when?
Since 2020.
It wasn't expanded at all?
No.
And I note in the photograph, there's tables and chairs and so forth. Are there tables and chairs inside the tent?
Yes.
And also there's, let's look at the next photograph. So let's look at photograph number P53. And that's, can you explain that photograph?
That's the area looking from the back parking lot with the tents on the right side.
Okay. And on the left side, is that the patio that you talked about?
Yes.
Okay. And patio has been there for a long time.
Yeah, I think since 2011.
Do you use heaters for the patio?
There was fire pits there since 2011.
Do you use those metal poles?
We have, yes,
Have you used that?
we have.
Okay. If the board said you can't do that, would it be something that you would not accept?
I don't want to say what they say, but I would like to have them for the outside. It's a nice, I mean, I never.
We're talking about the open fire pits and the open flame heaters, or one or the other?
But we're talking about the open.
I guess the heater, the heaters, the fire pits, propane fire pits.
Are they propane fire pits?
Yes,
And are they in the patio?
yes.
So you don't have pole heaters?
No.
Okay. And were they there when the patio was built?
They were there for, yeah, since the, yeah.
Are they anywhere near the tents?
No.
And I'm going to show you a photograph, ask you to look at P5, photograph number 4. I think that's another view of the tents.
Yes.
Okay, now, there's something on the right-hand side. What is that?
Just stage, when we have benefits, they'll do like silent auction items. A stage, yes. They do silent auction items there. They'll have a DJ when they have an event outside. And, they'll put some of the prizes up there.
Do the walls of the tent come down and be closed off?
Yes.
And if there's amplification inside the tent, is that less if the walls are closed? Is the sound less outside?
It is, yes.
Now, is there heat in the tents?
It's an enclosed heater that blows hot air.
Okay, is that something that's inside the tent or outside?
No, it's outside the tent.
Okay, and does that have an open flame?
No.
Is that something that's, your understanding, made for tents like this?
Yeah, they came and installed it.
Okay, and where's it located?
Right back here.
Okay, and is there ductwork that goes into the tent and
Yes.
lets the hot air in?
Yep, it's flexible duct.
Okay, so there's no open flame in or near the,
No.
now, as part of the last appeal and today, did you do a calculation of square footage of the building, the patio area, and the two tents?
Yes.
And I'm going to show you.
Well, there was, the last time we did it, there wasn't a tent there, but we did the total square footage where the tent is. So that would be,
I'm going to show you P6, and this is the square footage calculation. Is that a calculation that you did?
yes.
Okay, and there's a customer area. What area is that?
The customer area?
Yeah,
That would be inside the bar right here and here.
including, well, there's the patio. Is the patio separated out?
Yeah, the patio's up here, yes.
Okay, so you have 1,141 square feet for the customer area, and there's a party room. What's the party room?
Party room is right, there's an addition here that they did, what year was it? Sorry, I know.
So Tom, is the party room the area between what you're calling customer space and the deck?
Yes, yeah, yep.
But it's enclosed and it's part of the building, right?
Yes,
It's, when you're indicating to the right side of the building, correct?
yes,
Okay, so you walk out of the,
If you're standing in the back of the building, if you're standing in the front of the building, it would be to the left,
right.
right? I just want to have a clear record.
Yep.
That's why I'm asking.
so, and when one walks outside the party room, it's really part of the area that's marked as the building, correct? On this,
Yes,
one walks outside the party room, you come to the patio, and you calculate the patio area as 787 square feet.
yes,
Okay, and you didn't include the bathrooms, but they're broken down on the right side of this
yes,
calculation. So in terms of the area of the tents and the turf area, the whole thing is, by your calculation, 3,150 square feet.
yes,
Yeah, so the tents are 40 by 30, they're each 1,200 square feet by my math. So 2,400 square feet, would you agree with that?
yes,
So the total space, total customer space is 5,612 square feet. And the total customer and bathroom space is 6,093 square feet.
yes.
And it's on the exhibit, so you don't have to, I'm not tricking you on the math. How many parking spaces are on this property?
77,
So at the 1 per 100, your standard, you're well over even with
yes.
Can you, Counselor, you want to walk us through the 77 calculations? I don't see any parking. No, let's see, 8, 9, right? You want to take us right through that?
Since our last zoning meeting, I had the whole print with all the spaces on it. So it doesn't show it on this print. There's a whole other print I had from prior to that was already approved, the last zoning meeting with all the spaces.
You have 77 approved parking spots on-site,
On-site,
off-site?
on-site, on-site.
Can we see that?
I don't have that exhibit today.
By my calculation, just adding your own numbers, we have roughly 35 spots, I think, here. Where are the other 40, roughly 39 spots?
Oh, you have spots along this, right here,
Spots in the center here are double spots.
or double spots?
Right, I counted them. We have 8,
And then you have
9, 7 over on the left side, 3, and
Well,
8.
this one's not marked as the one I had for the last zoning meeting. So there's spots going along this fence area right here to here. There's also this center area that has parking spots. It's not noted on this print. I can get you that print, the print.
Okay, Dan, would you provide that at the next hearing?
And I anticipate we're going to go another night, so.
Oh, yes.
We'll bring it in and we'll count them up.
Well, we've already said at the outset that we were going to leave the record open
I'm happy to do
at the
that.
end of tonight, so.
Well, while we're talking about the plan, I'm interested in the area that is encroaching on the R6. There's a triangular area of parking area that shows, I think, the concrete wheel stops, and it seems to encroach into the property that is labeled as R6. Can you talk about that? Is there an easement there? Has that been legally adjusted? But by looking at the site, the property lines, there appears to be a triangular area of the subject property that overlaps into the R6 property, and I'd like to hear about that.
Are you talking about this area?
Yes.
Where I'm pointing?
Has that been legally adjusted? Did the residents of this property know that the yard pub parking encroaches into their lot?
Do you have any awareness that these concrete stops might go over to the other property line?
I've never been over there. There's a fence there and there's a bunch of weeds and,
So the area behind that we're looking at here is fenced, correct?
yes.
Are those the-
Other ones. Yes.
Yeah, you need to speak up, Tom,
I'm
so that
confused.
Arlene can type everything you're saying.
So were you aware that there's any encroachment? Have you ever heard?
No, I wasn't aware of it, no.
And the area that we're talking about in here, as I recall when I was at the property, there's a fence there, is there not?
Yes,
did you put up the fence or was it there when you acquired the property?
Part of the fence was, it was there, and then we just redid some of the fence. Some of the fence that was like broken, and
You know, no awareness one way or another whether there's an
no.
so we'll investigate that.
Please do. And also, it appears on this chart, you've put a tent over the handicap parking spot. Have you repositioned the handicap spot?
I'm sorry, I did, say it again, I'm sorry.
Your tent number 1 is now covering one of the previously designated handicap parking spots. Have you moved that handicap parking spot somewhere else?
That spot's over here against us, which I'll show you on the print that we provide for you.
And what's the little square box just below tent 1 with the X across it? Is that a drain?
That's the heater. That indicates the heater. I have a photograph of it. Introduce that. Get that.
So that's right now positioned over 2 parking spots.
May not be accurate.
No, that's not like the scale, the tent's not to scale.
I think-
There's-
I would also look at Exhibit P4. The aerial photo clearly shows what was referred to as AstroTurf definitely extends into that parking area. So I would update the plan to show the full extent of the improvements as they exist today, and label each parking space and number them so that we have a proper count.
Yeah, I'm going to show you a photo marked as P55. That shows the heater and the ductwork.
Yes.
And then up to the board.
P5. So that's not in your packet yet?
It's not, no.
And that is positioned, this heating facility has AstroTurf on either side of it?
It's not on the AstroTurf,
I know, it has AstroTurf on either side of it.
on one side.
Is this AstroTurf and this is AstroTurf?
Oh, that was a section that, just for the kids, we just put there, there was a little bag oak tournament.
You ever have a problem parking here?
No.
That's, okay, you can ask all the
I can
questions you
ask.
want.
I'm sorry. I didn't mean to interrupt your question.
Okay, so you've got AstroTurf now also to the right in P55. You've got AstroTurf in the parking area also.
Yeah, that was just temporary for, we had a kids bag o' night.
Have you ever had a problem? You have a problem with people with parking at the property?
No.
How do most people come to your establishment nowadays?
But mostly Uber. More Uber than drivers, put it that way.
So do the parking spots fill up on really regular occasion?
Rarely, if we have a big occasion, it will, but not normally.
There's parking on the street in front of the pub?
Yes.
With respect to the sound, there's amplification. We're going to have testimony from Kelly McLaughlin, who's the manager of the pub, and she'll talk about how that outside area is run. But have you ever taken time have you ever done readings of the decibel levels?
We did. We just did it last week.
What did you do?
I took 3 readings. I had the DJ come in temporary, just have the speakers up and turn it up high. And we took readings from the front area right here.
When you say you took readings, do you have a device that measures decibels?
We have a decibel meter.
And is that something that the employees also have to monitor? the
We,
levels?
yeah, or the security, we have a security, ID scanner for them, and they also have a decibel meter to make sure if it's any loud, they have to turn the music down. So they have one of them, they have a scanner when they're walking around, like checking IDs, and they'll go do a sound meter, like usually on the sidewalk, they'll do it, to make sure it's not like super loud.
So just to make sure the record's clear, you're talking the sidewalk on Westchester Pike.
Yes.
Okay, and that's the place where you measure.
Yeah, we measured there. I also measured back here.
Adjoining the C5 district.
Yes. Actually, the corner right here, I measured, and I have over here.
And you asked the DJ to turn it up to the top.
It was,
And what readings did you get?
Can I ask a question before we move off where he's measuring it?
sure.
You pointed out the side of the property that joins the township lands. You've Westchester Pike, along the quarry access road, and on the C5 boundary. And you said in that corner where it appears that you've got parking spots on possibly someone else's land. Did you take measurements from the property line that matches up with the lands of Linda Sorelli or William R. and Ruth W. Brown or the McGee's?
I don't know who they were.
Well, I
Let
think
your,
you
let your council point them out to you.
This is, the closest would be the lands of William.
Oh, I'm sorry, I didn't see
And
that.
Ruth Brown. So
This is probably, this corner was the closest. Oh, shit.
I apologize for this.
I'm stronger than he thought.
So this area right here was the closest to so that's why I want to take it closest to where the houses were, so that appeared to be, from my viewpoint, the closest to the houses.
And this was an opinion that you had that you only need to test in that one spot? 'Cause you-
No, I just want to test it to see what it was with the music up, just so, we would be under the decibel number. So I did it right here, right here, here, and over here.
Counsel, you want to, for the record, you want to point out where exactly those are?
So, and I think you pointed them out accurately in your question, but you testified at the.
Yeah, right over the fence there, like over the fence. I had it over the fence.
To the north side of the property.
Yeah.
Adjacent to 10-2, at Westchester Pike, correct?
Yes.
Did you test the ambient sound as well as
The ambient sounds like 60, and it can go up to actually like 65, 68, depending on traffic.
Okay, and at that spot with the sound volume turned up all the way, what was the volume with?
It was like, it went from anywhere from like 72 to 74.
And the equipment you're using, do you have any certifications on
Yeah,
how that was
the meter,
calibrated?
yeah, the meter actually has a certified calibration with it. I did by.
Will you submit those
Sure. Yep.
records of the readings and the calibration?
Yep.
And we may do it again, so, do it in a more organized fashion.
I would just, if we're going to, I don't think he's gonna call back and this expert to do those readings, so if we're submitting documents that are, well,
You can ask the question if he's a acoustical engineer.
sure, sorry, I was going to let him finish his
Right.
original testimony, and then
Okay.
I was going to cross him on those facts. But,
Okay.
but I would just, for the purpose of having them be official readings, I would object unless an expert is sworn in.
I videoed the whole
I
thing.
understand, but I would ask the board to give the credibility.
I'm sure you'll be at the next hearing as well, so
Yeah, I'm sorry.
you can object at that time. We don't have anything to object to now.
And Mr. Rafferty, not an acoustical engineer, he had a machine that decibel up, and that's what he found. So if we have to go through that exercise and keep the record open, to do that. So, just to finish up your testimony on this issue, at the point that you mentioned, the second point was where, at the bottom of the parking lot, adjacent to the C5?
Yes.
Down by the fence at the bottom. And what was the reading there?
64 maybe.
And then
I have it on video. I got it on video.
you also mentioned over where the point of the property adjacent to the R6.
It was 31 off, maybe 1 decibel from.
I'm sorry, it was.
Yeah.
It went up 1 decibel from ambient. Decibel from ambient.
In the 60s?
Yes, it was like, yeah, barely registered, barely registered.
So I'm going to have Ms. McLaughlin testify regarding the operation of the area. But Tom, what's the importance of this outside area? How has that worked out for your business?
We're a community business. I mean, we hold a lot of fundraisers. We do a lot of, we sponsor, we give back to the community. We do a lot there. We pride ourselves on that, to be honest with you, and it would hurt us because we wouldn't be able to have any of these functions. And
Big part of your business?
it's 70% of our business, probably 75% of our business.
People like the outside area?
They love it.
They prefer it over the party room with the deck?
The outside, like, there's no way. I mean, the beauty of having that is there's nowhere in the area, in Haverford Town at least, that has that. And why would we want to go elsewhere out of Haverford Town, keep the money in Haverford Town? And people love it. They love it. I mean, I'm sure some of you guys here have been there, but it's I think it's a community thing. It's not just a business thing. It's people come down there and have all their fundraisers.
I have no further questions.
So I have a question for the zoning officer. Jonathan, do you happen to have any of the records as they relate to parking and square footage from the last hearing available?
I do.
And if you object, then feel free to interpose.
I have that from the transcript from the June 2nd, 2022 hearing.
I'll just ask, does the zoning officer need to be sworn before if he gives us any testimony?
I'm sorry.
Does the zoning officer need to be sworn in before giving?
Yes, he should be.
It seemed like he was about to testify, so I
Okay,
just
you
wanted.
can identify who you are, be sworn in.
Well, Jonathan, raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name and the capacity in which you appear this evening?
My name is Jonathan Mount, M-O-U-N-T. I'm the zoning officer for Haverford Township.
Okay. And I asked if you had any of the information from the prior hearing available or with you tonight, and you said you did.
I do. I have the transcript from the zoning hearing case Z22-12 that was held on Thursday, June 2nd, 2022.
Okay. And I mean, there were two numbers that I'm curious about because it sounded like there was conflicting information, and I want Tom and Dan to have an opportunity to reconcile these things, unless I'm wrong, and then there's nothing to reconcile. But do you happen to know what the total square footage, customer square footage was at the last hearing?
Yes, from page 28, Ms. Poynton, or Mr. Poynton, excuse me, asked, quote, on Exhibit 7, which was your calculations, you have a grand total of 7,143 square feet, and that would require 72 spaces. So you are 73, as you indicated on A8, would provide enough parking spaces.
Okay. So what was the square footage again, Jonathan?
The square footage was listed then was 7,143 square feet.
All right. And on this Exhibit 6, P6, it's listed in total as 6,093. So it couldn't possibly have gone down as something was demolished, and I've not heard any testimony to that effect. So maybe you'll take a look at that and reconcile the two.
I'm sorry, I actually did, and there was a mathematical error on that document because they counted.
On
basically
which?
counted part of the same space twice, so I'll reconcile.
On the prior
Yeah, something
hearing?
like that.
Okay.
I did have that.
Okay.
Compared it, I showed it to Tom, I said, look, you counted this twice, so we'll go back and look at that, and whatever it is,
Yeah. I mean, as long as I want to know which one's
yeah.
accurate, which one you stand on. And Jonathan, with regard to the parking, how many spaces were provided for at the prior hearing?
They had an individual come in who had indicated in the documents that there were 72 parking spaces that met the requirement of 9 feet by 18 feet, according to the record.
Okay, so I think I heard 77.
Yeah.
So Tom and Dan, can you reconcile that as well?
Get out there and go over it again.
Yeah, especially with consideration to the fact that it appears from the photo, P55, that there's astroturf of what might be a parking spot or two. So,
No, don't. And I think that'll be,
Yeah, we do have that print I can bring up and take pictures.
We need an accurate number that you stand on, and
Right,
I don't
okay.
want there to be conflicting
I got you.
documents
No
from
worries.
the last
Yep.
hearing to this hearing.
Okay.
And, you know, we're not, if you've got equipment over parking spots, if you've got AstroTurf over parking spots, if you've got a place for kids to play in the parking lot, those spots shouldn't be counted, right? If you
Right.
can't park in it, they shouldn't be counted.
And if there's any question as to the legality of the property line too, we should know about that and get that cleared up. Because if,
I don't think either, any of us knew about, thought about.
I never even
I
heard.
thought you might,
jumped off the page at me as soon as I looked at the drawing.
Yeah, we didn't say it though.
it's up to you guys to reconcile that, because either part of the yard's property is in an R6 zone, or yard is encroaching into a neighbor's property, and from this, we can't tell which that is, so that's up to you to explain. All right, so, Tom, I'm gonna ask the board if they, you're through with your questions, right, Dan?
I am, yeah.
Kelly, do you have questions?
Okay.
Go ahead.
And if you can't hear me, please let me know. I'll try to speak loudly and into the microphone. Would you agree with me that as part of the prior zoning hearing board decision, you agreed to the condition that all outdoor patron use will be limited to the hours of 7 a.m. to 9 p.m. per the Haverford Township Code?
That's what the ruling was, yes.
Okay. And would you agree with me that one of the conditions was that you would remain in compliance with the prohibition on the amplification of outdoor sound?
Yes,
Okay. And would you agree with me that since this decision, you have used the outdoor patron area past the 9 p.m. time?
there has been times where, I mean, there's people who leave, they'll sit out, like, you know what I mean, it's hard to police if someone goes out and sits outside and has a cigarette, you know what I mean? It's,
Okay. And would you agree that you have used the amplification of outdoor sound since this decision?
yes,
Okay. And
You have our order, zoning order? Yes. Appreciate you.
would you agree with me that in the outdoor area, there has been the use of the portable heaters with a open flame?
the fire pits,
Yes.
there has been, yes.
Okay. And would you agree with me that you did not submit a building permit or any zoning permit for the second tent?
Yes,
Okay. Would you agree with me that you did not submit any plans for the proposed second tent?
that would be with the permit, right? So it'd be same answer.
Okay, there's separate parts of the code, so that's why I'm asking two times.
Okay.
Okay,
What I'm saying is if I didn't submit the permit, I wouldn't have submitted the dimensions, correct?
understood. And I guess at this point, just on the notice of violation issue, he's essentially admitted to all of the violations. I don't think there's a contention, at least in my reading of the application, that the applicant is saying that it was an improper, there were any procedural improprieties to the actual drafting of the notice. So I don't necessarily know what additional evidence could be provided for that specific issue because he just admitted to all of the violations on the notice of violation.
Do you want to be heard?
I just stand by my comments at the outset.
Which comment specifically?
Well, the comment specifically is that my client did not abide by the amplified music because he believed that condition or that condition had been rendered null by the change in the liquor code.
And let me just ask one question, though. If he were wrong, is that an excuse?
If he were wrong on that issue,
If his legal conclusion was wrong, and that the change in liquor code did not preempt this. Is that a defense to the violations?
No, that,
I guess I'm just trying to simplify things. If that's the only part of the notice of violation that you do not want to, I guess, admit there is a violation because we need to resolve this preemption issue, we could resolve all of the other issues if he's just admitting that he has done all of them. And I don't need to spend a bunch of time examining the zoning officer on that matter, and you can just address the variances because they're violations of the code.
His testimony is what it is, so.
Can I ask a question to the zoning officer? Is there any on the record there that shows that we appealed this first decision?
I'm sorry, that shows what?
Anything on the appeal of the first decision in the record do you have?
On the prior decision?
Yes.
Yes.
Do you know why it wasn't ever, the information was never sent to Delaware County? Was there a reason for that?
I'm aware that there's an appeal pending at Delaware County.
Oh, so there's no certain period of time that could go on for years, you're saying? I'm just trying to find out why.
Well,
I would
I'm
just
not
say
an
that
attorney.
Yeah, I would just object to, he
Yeah,
would not be in a
you're
position to
asking
know that.
legal questions. That's really not his purview.
All right.
Yeah, so if your attorney filed an appeal with Delaware County of our decision, then all the township does is they assemble all the documents and the record, and then I sign a certification of the record, and they ship it off to Delaware County, and then we're basically out of it.
Right, but that never, I'm just trying to just, you
No,
know, I mean, I think,
well, I'm happy to
I
give you an
should be answered
explanation.
with that, you know, I don't know why that was never sent up, you know?
But it's not on him to submit.
Oh, no,
or us.
I was just
You guys
asking him if
appeal.
it was on the record.
Yeah, yeah.
Would there be any reason why that it was ignored, or I'm just,
But if it's in Delaware County, I'm sure they have it docketed, and I have no idea. You can
Yeah,
ask.
you'll have to
ask
work with your
Dan
counsel
the
on
status
the
of that.
legal questions.
okay.
So I think we should take to, and Kelly, why don't you talk to Dan and make sure that there's really agreement, because I hear some ambiguity with the way that the
Yeah, it
answers.
sounds like I think we should just proceed because I was just trying to simplify things and it seems like it's going to be a long.
And rather than have Jonathan testify for 30 minutes.
Yeah.
If you and Dan can talk and there really is a stipulation, then let's just put that on the record and we can move on to the variances. So we'll take a 2-minute recess. Dan, would you talk to Kelly?
Sure.
Okay. Do we have any sort of agreement?
I believe that we do on a couple of things. It was my understanding after we spoke that due to the admission to the elements in the notice of violation, and because there is a separate Court of Common Pleas appeal outstanding right now on some of these issues that they have contentions with, it makes sense that he withdraw that notice of violation, proceed on the variances, and we resolve the matter that is outstanding at the Court of Common Pleas. I would let him speak. He also had mentioned that there were some individuals who wanted to speak on behalf in public comment, and I, on behalf of the township, have no objection to if the board were to be inclined to let them do that early. Not as witnesses, but as just people speaking in public comment. So I will turn it back to
Ms. Milka, can I just make sure I understand? So some portions of the violations have nothing to do with the 2022 case and our decision in that and the appeal
Yes.
of that. So some do, some don't. Are you distinguishing between violations
if
that
they-
relate to our
so sorry.
decision and those that don't?
So for the purpose of the notice of violation, if it seemed to me that he was just withdrawing the entire appeal of them, and therefore the notice of violation would stand and they would correct, it would be my understanding that they would correct and come into compliance on these issues, work with the zoning officer until we resolve that outstanding appeal at Commonwealth, or until this board were to grant them variances that would change the outcome of whether they'd be violations anymore or not.
Okay.
When we're talking about, I'm sorry, when we're talking about variances, so as I said before, the issue of the hours of operation, that's a request that we're making to amend the condition for variance, and also an argument that it doesn't apply to this property. So that would remain. With respect to the amplified music, which was a condition, again, we would seek to amend the condition, and we're making the argument also that the right of the township to enforce that condition is preempted. So that's that's what we're observing. With respect to the second tent, we will most likely be filing a permit application for that and do that to try to comply and work with the township zoning officer on that. So those are that's where we are.
So the second tent will come down pending all that?
I think it's going to have to, but well, we're going to come back here, we're going to file an application for the permit.
That wasn't the question I asked.
I'm not prepared to say we're going to take the second tent down.
I would just say they have a specific amount of time within the notice of violation to come into compliance, or else there are consequences to the violation, as is stated in there, as their attorney knows. And so within that time frame, if they're intending to apply for the permit and work with the zoning officer, they have a certain amount of time. As we're in this appeal, they have an amount of time, and if they were to withdraw their appeal, they still have a prescribed amount of time to come into compliance. So
Because the second tent wasn't part of
that
our
was not
original
part of the
approval.
initial permit, and if they withdraw the notice of violation, then they are actively in violation of that, needing to remedy it. And one of the steps that's outlaid in this zoning, in this notice of violation, is that they need to submit a permit. So that would be taking a step toward rectifying the issue with the tent.
But from the board's consideration, if the appeal to the notice of violation is withdrawn, then we can just move on to the variances. And presumably the variances would address or make you no longer in violation, and if they were granted. And with respect to the second tent, you're going to submit a permit. It'll either be granted or it won't. If it's not, you've already indicated that you'll file another case with the zoning board, which is fine. But just for the purpose of this hearing, the appeal of the notice of violation, is that withdrawn then?
It is, yes.
And you agree?
Yes.
Okay.
So this is active. We have a current Court of Common Pleas separate issue. And then all of the other areas of relief that have been requested by council are still before this board, and the township at this time makes no, does make a position on whether it was preempted, but other than that fact, the township does not at this time have a position on the other variances. However, we did discuss getting a continuance other than having potentially the witnesses who came, the public who came tonight to speak in favor or opposed be able to do so since they came. And then we'll come back, because there are some other issues that it seems like we would benefit from having some clarity on, and then maybe have a smoother rest of the next hearing for you all with the information that you need.
Okay.
Ms. Melchior, Mr. Koval had said that he's going to prepare a legal brief analyzing the preemption issue. Are you going to do the same?
If I may, if I could have just time to respond to his brief once he submits it. I mean, I can do a dual brief, but if you want us to submit them both at the same time, we can do that. Or if I could respond, give him the opportunity to respond to.
I have no objection to filing it first and having her respond. I'd like a little bit of time.
Yeah, you both need time, though,
Yeah.
in that argument. So I point this out because, you know, if she wants to wait for yours, the added time here will build up. At some point, the tent's up. You know, you're gonna allow the tent to stay up if they apply for a permit?
The tent is only able to stay up for the amount of time that was prescribed in this notice of violation. If they apply for a permit, that is not make them in compliance with the rules.
I just
And
want to make
so
sure it's clear.
They have the amount of time, they had, I believe it was 30 days to, I mean, we can speak with the zoning officer to determine an appropriate amount of time for them to be able to do that. We would expect it to take a bit of time to resolve these issues, and they properly appealed the notice. So we're not trying to do any kind of tricks or anything. But I think within a reasonable time, I'm not sure what the standard amount of time is. I'm sure there is, and I can look into that. But I'm happy to provide a brief. If you want us to both provide them at the same time so that it could speed things up, I'm happy to do that as well. That's fine.
I have no objection either way, and I think we're going to benefit from trying to work this out and have dialogue rather than having the dialogue in front of you all. Because there's going to be,
That's fair. Okay, I just,
That's what I would,
yeah, if you do the brief serially, I understand that point. It may be a little bit longer before we can deal with the variances because preemption is so, I think, important to at least your request for an amendment to the prior one.
if we don't do them serially, then someone's going to be filing a reply brief. And,
Yeah,
you know,
I got it. Okay.
all right, and how much time would you need, Kelly?
To respond to his
Yeah,
brief?
yes, once he submits it.
If you give me 2 weeks, maybe 10
Okay.
days is fine. I mean, we'll turn
Okay.
it around.
that's fine.
And how much time do you think you would need, Dan?
I need more than 2 weeks just because, like I said,
Sure.
I'm not going to be here
It's no problem. I'm just asking so we can have some date on it.
15th of September or something like that. 20th of September.
So we would reschedule this. Are you going to want, or Jonathan, do you want to reschedule this now or, I mean, don't we?
No.
No?
We're
Okay.
going to listen to the public. Dan's going to put on another witness.
No, I mean, for when we do continue this hearing, we need to build in enough time for the brief writing.
And
Oh, yeah.
Yeah, I
So that
can-
we could
I-
avoid re-advertising it
Right.
potentially.
Yes,
Yeah.
yes, and to be honest with you, we're not going to be at the September 18th meeting at this point in time. So the next meeting, actually, the second we don't meet, the next meeting after that would be October 16th.
that's fine.
Okay, so if he files his brief by the 15th of September, if we could file ours by
30th?
30 would be 2 weeks.
the 30th?
Yeah.
Okay. If we file ours by September 30th, and then,
So yours will be due the 16th, Dan. So get one more day, and then 2 weeks later on the 30th, Kaylee's what to do. And then at the conclusion of tonight, we're going to continue the case to October 16th. Okay?
Yes, that's fine. Thank you.
Same page? Okay,
With respect,
very good.
sorry, with respect to the other witnesses, I can bring my witness back at a later time because I understand there are other people here who have to get on.
There are, and if that's your desire, we'll hear them now, or you can bring them back
Well,
to the October hearing.
I would ask, since we're going to be coming back, I'll have my witness come on, but I would ask the board's indulgence to hear the people from community.
Oh, we absolutely will,
And-
regardless of what anybody thought, we were going to do that anyway, so.
Thank you. So I would ask that the matter be continued, subject to hearing people from the community speak to the application, and then we'll present further evidence at the continued hearing.
Okay, thank you. Very good. So with that in mind, I'm sure everyone heard that, and you can take down your chart there, Dan.
And the continuance would toll any timelines.
That's fine. If you need a letter on that, all time limits are pulled.
If you just put it on the record, I think we're fine.
I agree.
Okay.
Okay. So with that, I'll ask any residents that receive certified mail that wish to testify? Anyone that received regular mail? Any other residents? Please come forward. By residents, I mean residents of Haverford. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and address for the record, please?
Kristen Meehan, 205 James Drive in Havertown.
Kristen Meaden. And what would you like to tell us, Kristen?
Okay, I wrote a speech here.
Okay?
Okay. Good evening, members of the zoning board. Thank you for your opportunity to speak tonight. I'm here to express my strong support for the Yard Pub's continued use of the outdoor tented venue for hosting graduations, funeral luncheons, community celebrations, and family-friendly events in our great community. The Yard isn't just a business. It became a vital gathering place in Havertown. At a time when authentic community spaces are harder and harder to come by, the Yard has stepped up to offer something no other local venue can. A welcome, flexible, family-oriented outdoor setting that serves our town in countless meaningful ways. From graduation parties to fundraisers, birthday celebrations to funeral luncheons, the Yard has created a space where people come together, connect, and celebrate life's big and small moments. Local schools, public, private, and parochial, have all held events there. Teachers, parents, and students alike have come to rely on it as a safe, accommodating, and enjoyable space. And it's not just for adults. The Yard is one of the few venues in town that is truly kid-friendly. The outdoor space allows our kids to hang out and enjoy each other's company. It's accessible, inclusive, and family-focused, something Haverford should be proud to support. Let's be honest, there's simply no other venue like it in Havertown that can host multiple parties at once and do so affordably. The combination of outdoor tented space, community-minded service, and family-oriented design makes it irreplaceable. Taking that away wouldn't just affect the Yard as a business. It would be a loss for the entire community that has embraced it. If the township does not allow the continued use of the outdoor tents, it will have a serious impact on our ability to gather. Large charitable events, fundraisers, and multiple graduation parties would no longer be feasible. These tents provide the flexibility and space we desperately need, especially during the busy spring and summer seasons where weather is unpredictable. And if you've had a recent graduate, you know how hard it is to find a very nice venue in Havertown on the date you want. It is often stressful and competitive, especially for families who want to plan something meaningful for their children. I know this firsthand. I helped plan the 5th grade graduation party for my son at Manoa Elementary. Because of the outdoor space, we were able to create a beautiful event where all the students and families of Manoa Elementary's 5th graders could come together to celebrate before entering middle school. The kids had room to hang out and make memories, and adults could enjoy the moment with them. That kind of event simply wouldn't be possible without something as simple as a tent. We should be encouraging local businesses that make our town stronger, places that bring people together, support our schools, most importantly, and give families spaces to make memories without having to worry about the weather. That's exactly what the Yard does. Please allow the Yard to continue using its outdoor tented space. It's not just a restaurant's outdoor tented space, it's part of our community. Thank you for letting me speak.
Thank you for coming. Any questions for Kristen? Ed?
Sorry.
No, that's all right. Ed?
Questions?
No question.
I'm sure there aren't any, but I have to do this for the record.
Sure.
No question.
Jesse? No questions. Okay, thank
No
you.
questions? You sure? Okay, thank you.
Any other residents? Any other members of the public that want to comment? Hello, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and address for the record?
Christy Foley. I live at 18 Treaty Road.
Is that, what was your last name again, Christy?
Foley.
And where's Treaty Road?
Drexel Hill, PA.
Okay. What would you like to tell us?
Thank you for allowing me the chance to speak tonight. I'm here as a proud Havertown resident and, more importantly, as a parent. My child recently graduated from 5th grade at Manoa Elementary School, and I want to share what a meaningful role the Yard Pub played in that celebration. After the graduation ceremony, the 5th grade all came together at the Yard for a party that our kids will never forget. It was more than just a get-together. It was a moment where memories were made, where the kids could laugh, play, and enjoy each other's company one last time before moving on to the middle school. And it gave parents a chance to connect and celebrate the milestones together in a relaxed, welcoming space, and we did not have to worry about the weather. We never would have been able to book this venue without the tents in case of rain. There simply isn't another venue in Havertown that could have hosted that many families, let alone with the kind of open, kid-friendly environment that the Yard provides. The outdoor tented space made it possible. It gave us room to breathe, space for the kids to play, and a safe, comfortable atmosphere for everyone involved. Without the tents, events like that just won't happen, at least not the way that they should. No other venue in the area offers that kind of capacity, flexibility, and community-minded design. The yard has filled a real gap in our town, providing a space that brings people together in a way that few businesses can. These are the kind of moments we want for our kids: joyful, inclusive, shared experiences that they'll remember for years. The yard makes those moments possible, and it would be a shame to take that away. Please allow the Yard Pub to continue using its outdoor tented space. It's not just about business, it's about community, connection, and giving our families a place to celebrate together. Thank you.
Okay, any questions for Christie? Ed?
No question.
Bill?
No questions.
Jesse? Kelly? Okay. Oh, I should have asked you too, Dan, but presumably you have no. If you do, let me know. Anyone else? Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and address, please?
It's William Lane Jr., 26 Fairfield Road, Havertown.
I'm sorry, what's your address again, William?
26 Fairfield Road, Havertown.
What would you like to tell us?
I don't have a prepared speech like everyone else does,
Not necessary.
but I have some prepared notes. We're not talking about the big box stores, the Lowe's, okay, or the Giant, all right, or even the Kohl's that's right next door, all right? We're talking about a family-owned business, family-owned, with the families like the Murphys and the Raffertys that have been a staple in this community for roughly 45 to 50 years, okay? They bring that type of community together, all right? People that know them, go to them, ask for them for help, the fundraisers, the local baseball teams, softball teams, soccer teams, anybody that goes there and asks for their assistance or to sponsor or give some money, they're there for them, okay? If they need a fundraiser, they're there for them. They provide the space. There's not a space that you can go to without asking, to shut down Brookline Boulevard for any other problems or big events that Havertown has, all right? That business has the ability to host the people to come there, and the tents that are there provide shelter. And I don't think we should be discouraging shelter, all right? So it's still a temporary structure. It's a tent, okay? Yes, it could come down, all right? But it also is providing the patrons, okay, some shelter there. And I think that's the major issue here. It is community-oriented. It's not like people from Philadelphia or Montgomery County are renting out these spaces. It's Havertown people that are coming here and renting out these spaces. Maybe some Drexel Hill people as well, but mostly Havertown people. A friend of mine died last March, okay, suddenly. Young man, okay, with 5 kids and grandchildren, okay, of a tragic stroke that he had, and the amount of friends and family, there was just an outpouring from the community. We had, people trying to bring him back, but it didn't happen. Okay, so the funeral luncheon that encompassed hundreds of people to come out and show support to the family, the Yard Pub was there to donate the venue, okay, and offset some of the costs that was there for them, okay? For a family struggling like that, that's pretty good. No other venue in Havertown could have done that. No other venue. We talk a lot about the noise here, okay? There's a major roadway there with Route 3 being there. There's sirens, ambulances, police cars going up and down that road constantly. But you don't hear anybody complaining about that. Obviously you shouldn't, all right? But we're talking about maybe some music, okay, that people like to go and listen to and relax after work with a beer and stuff like that. I don't see what the problem is, as long as it's well within, the timeline for excessive noise, which is usually around 11 o'clock, all right, on the weekends. All right, I think they've complied there. I'm a patron there, okay? I've utilized that establishment. I've had birthday parties there. I've had graduation parties there, and they're very accommodating. I don't know how many complaints there have been with this. That's not under my purview, okay? But I think that holds a lot of weight here. if there's a major community outpouring for the way they handle business or the way they do things, then okay, well, we maybe have to adjust it. That's why you guys are here. But I don't know what has sparked all this controversy about AstroTurf, which is movable, okay, fire pits, which everybody has fire pits for, okay, and noise that doesn't seem to be a real problem from what I'm hearing. So why not any compromise? You know, I know the legal battles that you guys are going to have to go through with this. Maybe we just compromise here. Keep it a community establishment. Keep it in the community, okay? And keep people going there. Support local businesses. And that's why we're here. Thank you.
Okay. Questions? Dan, Kelly, Ed,
No question.
Bill?
Yeah, thank you.
Jonathan, Jesse? Okay, anyone else? Come on up. We're easy to talk to, I think.
You can talk a mile a minute, but not in front of a crowd.
Please raise your hand, right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your full name and address, please.
Ellen Meehan, 36 Rodman Avenue.
Wait, spell your last name for me, please.
Meehan,
Any relation to Kristen? I'm only kidding. It doesn't matter. What was your address?
36 Rodman Avenue.
What would you like to tell us, Ellen?
So I've been a lifelong member of the Haverford Township community. I grew up in Ardmore. I've moved 10 minutes over here to Havertown. I've never left the township. For the past several years, I've been highly involved in planning and executing the Haverford Youth Football and Cheerleading Beef and Beer benefit. We've always had it hosted at the yard. They make amazing donations for our baskets to be raffled off. We have over 250 athletes, so our turnout is usually pretty large. We usually get about 150 to 200 family members, we'll say. Ample space out in the tent to be able to display our raffles and also just to socialize. It's nice to be there without our children who do not come, you know, for 5 minutes it seems, but, and go on from there. With these funds that we have raised, we have bought new equipment for the kids, including newer, safer helmets to prevent the concussions and the shoulder pads to protect for the neck injuries. The open outdoor space has encouraged more participation in the past few years because some of the families are still a little concerned about the COVID risks. And with post-COVID mentality, it is nice to have an outdoor space. You're not crammed in one room. 2 years ago, after winning the championship, our varsity team did gather also in the tent with their families, and it was a nice open area. Like I said before, the kids were very welcomed. They were able to be outside. They were still having a football catch even after they won. And the parents were able to celebrate a long season. Personally, I've attended multiple fundraisers at the Yard Pub, all supporting local causes. The Kevin Kane Foundation, the Jay Foundation, Haverford High School's Blast program, and the Bonner Apprendi Athletics Department. They all drew large turnouts, which really, there's no other place in Havertown that can host that many people. In addition to hosting these events, I've also had 2 christenings, 2 communions, 3 funeral luncheons, and a surprise party, all hosted in the tent. I have a large group of friends and family. The tent provides ample space. Again, we tend to enjoy being the outdoor space more than indoors because we all work inside. We want to be outside. In conclusion, the outdoor space, large presence for the community. Parents' phones are dinging. Sorry.
Do I need to say it? Okay.
Okay. To gather, to celebrate, to fundraise, to listen to amazing music, and all of town, that Haverford Township is the locals. It's a locally owned business, trying to keep all Havertown residents within the township, keeping their monies, their funds to support local. Thank you.
Any questions for Ellen? Ed?
Other than bring up that Ellen was my next door neighbor for the first part of her life.
First, like
I don't know if that's a good thing or a bad thing. From Ellen's perspective, not from yours. I'm sure it's a good thing. You were lucky. Question? No. Anyone else? No one else? Okay. I do just want to say one thing, and we can't really have a back and forth, and I probably shouldn't. Dan kicked me under the table. But we did grant the 110, last time we had this hearing, and certain loosening of the noise and not noise, but the music authorizations. So this is really for a second tent. And I wonder out loud, Dan, what the argument is to need a second tent, because all these fundraisers had been held with one tent at that location. But I'm sure you're going to make that case at our continued hearing, and we need to consider the effect of the bands until 11 o'clock and how the noise might echo, because everything sounds louder when the road noise quiets down. It's just the way it is for some reason when there's less other ambient noise. And, and where we really measure to the property line or the structure. But I'm sure you're going to address those issues at the next hearing. Okay. So any other administrative matters on this case? Okay, with that, this case is continued to October 16th, 2025. Dan's brief will be due September 16. Kaylee's September 30. And with that, we're going to proceed to our next case. Good night.
Thanks. Thank you.
Let's go Jen next, yeah. Jen. I'll try not to butcher your last name. Oh, we'll go off the record, Jeff. Jeff. My alter ego, he's in me. Mr. Wagner is about to have me put away. Okay, our next case will be Z2520, Mustafa Smith Jones, owner of 978 Township Line Road, Wynwood, PA, DC folio number 2208-010610. And I won't read the rest of the description into the record unless somebody specifically requests that I do so, because I read it at the initial hearing. No objections?
No objections.
Cool. Jen, where were we? Where'd we leave off with this?
All right, so I think as a brief summary of our previous hearings, we have a proposal. We have made some changes, but in general, it stays very similar in terms of overall use. It's a mixed-use property with a basketball training facility on the first floor as a commercial use and apartments above. I'm going to go into the details of what we changed later, but as further summary, we had Mufasa testify about what his business was. It's a one-on-one training model where he trains one, maybe two students personally as basketball, in basketball skills. There's no large events, there's no games being played, it's not for competition, it's just this one-on-one training facility. We had our traffic engineer, I believe, testify that there was no impact on traffic from this. And I think largely, and the neighbors had expressed some concerns as well as the board, maybe about the size and necessary height and number of units and that sort of thing, and parking concerns. And I think we have addressed a lot of those concerns in our revised plans that I've submitted or that I've brought up. I believe we're on Exhibit L.
That's what I have. Too.
Okay,
L.
I think we all agree it's Exhibit L then.
Exhibit L, you had Exhibit L, wasn't it the comprehensive plan that you submitted?
It's M, excuse me, it is Exhibit M, you're right, I wrote down M, I just remembered the wrong letter.
So we resume, the next exhibit is N?
M, as in Mary.
Oh, so the last exhibit was L?
Yeah.
I think we talked past each other on that one. Okay, so this new exhibit is M?
Correct.
Okay.
And so
And we also had some people come in and tell us what a great guy he is.
correct, we had numerous of Mufasa's clients come in and talk about how all the wonderful things that he has done for them and their families in terms of training and life experience for their children. So, in an attempt to try to find some sort of middle ground here and also, really do find the minimum variances necessary here.
Yeah, because you're asking for a lot.
Correct. Notably, we have removed the third story, and this brings it into height compliance. Our building will be 35 feet tall, which is what is allowed under the code. In doing that, we have also reduced the number of units from 8 total to 6 total. There are 5 two-bedroom units. They're still really good-sized units. They range in size from 1,042 square feet to 1,254 square feet. So those are still really nice-sized two-bedroom units. There'll still be 88 accessible units as well. And we have one sort of junior one-bedroom unit, which is 460 square feet. So we've reduced the number of units from 8 to 6, and we reduced the height from 45 feet to 35 feet, which I believe we no longer need a height variance at that point.
Jen, associated with the reduction of the residential units, the impact on required parking?
So I was just about to talk about parking. Good point. So this,
Bill always dials in right on the
it was literally the next thing on my list here to talk about. So with reduced unit count, of course, we had a reduced parking demand, and we were also able to reduce the number of overall parking spots in the project to provide for better traffic flow. So we are presenting the project with 22 spaces. I believe 17 are underground and the rest are in the front of the building, which meets code requirements. Depending on how you look at our use, if you do 2 for each residential unit, that's 12, and leaving 10 available for the commercial use. If we consider this a sports court, which is one of the categories for parking, it's 1 per player, one spot for every 3 players, and we're going to have no more than 3 players. If you do it as a area of the lot, altogether 1 space for 1,000 square feet, you would be at 17 spaces, and we have 22 spaces. Basically, however you kind of interpret the code here, we're providing more parking than what would be required depending on how you interpret the use of the property. But in essence, we have 12 spaces for residents and 10 spaces for a commercial use that will probably never need more than 1 or 2 parking spaces.
And so what's the square footage now of the, I guess, ground floor only commercial use?
Yeah, it stayed the same. The ground floor commercial use has stayed the same.
And that is, just remind me, it's been a little while. If you,
I believe it's like 5,300, right around there.
okay.
I don't know the exact number, but I do believe it's on one of the plans. It's labeled on, I think, maybe the 4th page or something like that. It is in the plans, and I think it's right around that number. We did also move the building up 1 foot. Let me go back to talking about the parking. I'm sorry. So we also now have 2 driveways, one which will be exclusively in and one which will be exclusively out, to address some more of the concerns about, having to turn in and out of the property. It'll create an easier on and off ramp there for what we know is a busy road, and hopefully addressing some of the concerns the board and the neighbors had about, people accessing this property. Also on the plans, you can see that we have a gate to the lower level parking so that it'll be a single car use, to prevent, people from perhaps having any sort of accidents on the ramp down. There'll be a gate system that'll allow just 1 car to be on that ramp at any given time. So we did look, and in reducing some of that parking, we were able to move the building up by 1 foot. I know that that's not still anywhere near the required rear yard, but we were trying to do what we could do after hearing the board's concerns and the neighbors' concerns. So there is a 6-foot rear yard. It does also now, however, contain the second means of egress, which is a staircase off of that 2nd floor in the back that would be primarily used for emergency use as a second means to get out in sort of an emergency situation.
I'm sorry,
Sure.
I just want to stop you there just because you're talking about it and it's easier since we know we're now, you've Per the Exhibit M plans, I see that you did add a stair from, and the reason that we brought the question up of that stair was not because we were trying to critique the architectural design of the building, and that's obviously, there's life safety code would be reviewed at the permit level. But the question was, what would it look like to add a stair, and what impact would that have on the setbacks? My understanding from talking to the zoning officer is that a stair, it needs to be counted, only 18 inches, is that right, Jonathan, is allowed to be counted as extending into the setback, but other than that, you would have to count towards to the edge of the stair. And I see that the stair on the back, might be about 3 feet off the building and 3 feet off the rear property line, and then it turns the corner and makes a it almost looks like it completely fills the side yard on the top left corner of the drawings. Is that correct?
So at this point, if we do have our design professional and an architect here, that might be the best person to address your questions, as I am not an architect or design professional. But I think you're seeing it correctly.
Yeah.
And so if you want to just hold that question for 1 second while I just make sure I finish summarizing our changes. I think I actually have summarized our changes. I know what the other thing is, and I'm not sure, in doing this, we did note that I believe in our application, we said that there was a 5-foot side yard. And as you can see on the plans, it is smaller than that. One side is 4 foot 6 inches and one is 3 foot 10 inches. I believe that changed since the last drawing to accommodate some architectural changes as a result of removing the second floor. But again, I will let the design team talk about that, as that is not my area of expertise. And then we can talk about things that are my area of expertise. We also have our stormwater management engineer here today to talk about stormwater management. So why don't you guys come up and put your name, who you are on the record, and I'll kind of go from there. Well, Bruce, why don't you go?
Let's call one first.
Yeah,
Who do
so-
you want to testify first?
Bruce, well, they're both part of the design team, so there might be overlapping questions. That's why I kind of wanted both of them here. Bruce, can you just put your name? You've already testified, so put your name and address on the record.
Bruce Cheatham, design professional. Bruce Cheatham, Cheatham. Design professional, 3502 Scotts Lane, Philadelphia, PA.
Was sworn at the last hearing?
I'm sorry, Suite 1102.
Yes, and Bruce testified at the last hearing, and I believe we qualified him as a design professional.
We did.
And then we also have a licensed architect.
Yeah.
I don't think Tom was at the last hearing.
What?
No.
He wasn't.
No, he wasn't at the last hearing.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Full name and the capacity in which you appear.
Thomas Wiedemann, Wiedemann, registered architect.
And I'm just going to ask you a few questions about your professional background. Can you just explain your experience as an architect, your education, that sort of, just a brief overview?
Yes, I'm a registered architect for 25 years now. I'm 30 years experience. I've also had 5 or 6 years construction experience. I was brought on this job through Bill Ritchie, who was an architect that I've worked with since '94. He's actually my first boss ever, and he's extremely skilled. He's worked on this stuff all the time, and he wasn't able to come tonight. He asked if I would sit in, but the two of us will be working on this project and along. Yeah, Bruce.
And so I would just like at that point to offer him, as an expert, as a registered.
Just for you appeared before this board on many previous occasions, correct?
Yes, I have.
You've been accepted as an expert in architecture by this board many times, correct?
Yes.
Any questions or discussion from the board?
You haven't lost your license or been censored or anything since the last time you testified in front of the board?
No, I have not.
My only question, Tom, would be, are you going to be the architect of record, or are you in an advisory role?
It'll either be me or Bill Ritchie.
Okay. There was a stamp on the previous set of drawings. Whose stamp was that?
Bill.
That was Bill. Okay, thank you.
Yeah, he's dealing with some health stuff tonight, so he couldn't make it to the meeting.
Okay, so we'll accept Tom as an expert in architecture.
So much. I figured that one would be. But, all right, so I guess then we can start by, I believe there were some questions. Jesse had questions about was it Jesse or was it Bill? I can't remember. Had questions about the staircase.
The stair, yeah.
Yeah.
I raised the question of the stair because I was worried, we kind of, Ms. Vitale, who was here, we both kind of agreed in our professional opinions as architects that there would need to be a second means of egress from the second floor. We wondered how that would have an impact on the setbacks, because that's purely that's what's before this board tonight. And we want to just understand the full impact of the setbacks, and so we now have a revised plan that shows, and you guys could describe what that is and how we should be interpreting that for the setbacks.
And whoever's best to describe it, just one at a time, and please talk into the microphone. Bruce, you speak quietly. Arlene's gonna
I'll try my best.
tase me or something.
I'll try my best.
Come talk to you.
Yeah, so we added this stair to the very rear and we moved the building up 1 foot. Originally, we were thinking that it was going to be a switchback stair and we would land, and that's why we needed the 6 foot in the rear. But we were just feeling like we didn't want to have our patrons exiting to the rear, so we ended up with more of a straight run approach that goes around the side. We weren't including the stair in the setback. It's not covered area. We don't normally include egress stairs in that capacity for the setbacks, but I did hear the a mention of the 18 inches earlier a few moments ago, that potentially a portion of that would be included. It's just we don't normally include it, so I will definitely look into that as well. But what we have shown currently is what we're proposing.
And I'll just jump in terms of the code. When I was reviewing the code, I don't know if you want to talk about the township code regarding stairs and occupied area.
Well, we basically needed that second stair in the back to get the separation distance between the two different stairs. So you've got 2 egress stairs coming down. And we'll have to look into if it's over the setback there with that 18-inch code that was in there.
When I had looked at the code, I saw that, stairs weren't necessarily included. There was other projections over 18 inches. But as I interpreted the code, the stairs were just universally accepted as not part of the occupied area. I may be incorrect about this, but that was our interpretation.
And
so.
I may be incorrect, but luckily we have the zoning officer.
Okay.
Mr. Chairman, can we
Yes,
ask John
go
to
ahead.
clear this up for
And
us?
I'm not going to swear him unless Jen requests that I
I
do.
think he was swearing.
We just wanted an opinion, but not in this hearing.
He's fine.
Go ahead, Jonathan.
Thank you. The ordinance is somewhat ambiguous in this particular wording. And I think the intent was to allow, say, a house that's got a couple of stairs coming off a porch to project into a side yard. I don't think it anticipated an entire set of egress stairs that is the length and size of this to completely occupy a required yard. So I think the way to address it would be just to put it into your variance request, and we can give it the weight it deserves.
Right, understood. And obviously there is some ambiguity, as clearly there's 2 people here who have different interpretations. So, and so with that, I would just say, and Tom, I'll ask you, is there any other place for us to provide the second means of egress that would somehow lessen the impact on a variance and still provide meeting with the fire code or building code?
We do need the stair in the back, and it needs to be minimum 3 foot. I don't know if there's any way we can squish the building.
You guys need it one at a time, and both you guys are
Okay.
soft talkers. You need to
Yeah,
speak more loudly, please.
We can look into see if we can get the stair along the side without affecting the setback, but it's pretty tight.
Yeah, it's because of the ball court on the first floor, we're dealing with a pretty tight situation. Our main focus was just to make sure that for this egress there, that we got everyone out in a safe manner. There are different options potentially, but really having it on the rear is going to satisfy more IBC codes, and we'd prefer to have it off the rear. There is a little bit more space on the opposite side, and we can potentially swing it to the opposite side and not the lesser side. It wouldn't affect the shape of the building or anything like that. It would just be the stairs itself, but it still would be in that, setback space technically, based on how we interpret the code.
But could we, instead of having, so what you're talking about is instead of having, if I'm hearing you correctly, instead of having, if we're looking at the front of the building, instead of the stairs going to the right, which is where the dentist's office is, we could have them go to the left, which is where there's park space, and the side yard is a little bit larger, and it's also farther away from any residential structure.
Yes. Without any changes to the building.
Jesse, do you have any other questions?
Well, I do, and so there was talk of moving the building up 1 foot, and I'm looking at, I'm directing to Exhibit M, and I'm looking at page A101, which is the first floor plan, and there seems to me a rather large area in the front that could be reduced now that you've introduced the 2 driveways in and out, and there's a dimension of 56'10" from the sidewalk to the side, between the 2 sidewalks. You're showing your required parking spaces. It seems to be a very generous turning area, and I just wonder if the entire building could be moved up closer towards the street to provide additional space in the back where you could do a switchback stair and not wrap around to the side yard setback, and therefore just need less encroachment onto the side yards and even less encroachment into the rear yard by moving the building even closer to the street, to Township Line Road.
So we're talking, I'm just gonna hold this up. This is A101, which is, I believe this is the plan we're referencing.
Yes.
So we're talking about this area here in front of the building and parking space. Would there be any ability to move the building up further into this and still maintain turning radiuses?
We do have a little bit of space between where the turn radius is and where our sidewalk begins, but that move wouldn't, we would still be asking for relief on the rear setback, no matter what.
Right.
But maybe not as much.
Potentially.
And then not encroaching into the side as much as you are now with the stair, depending on how we
Because we
interpret.
still have to have a sidewalk that would then run along this, along the rear and then along the side as well. So, it give us a little bit more impervious, but.
And Jennifer's comment, do you agree that if you couldn't do the switchback stairs and you needed to wrap it around the building, you could move the stairs to the other side of the building so it's closer to the park rather than the dentist's office?
For the switchback?
No, just for the wraparound staircase, just putting it on wrap it around the other side of the building.
Yeah, where it's a little bit more square footage. Yeah, absolutely.
Okay.
We've looked into both options. We've looked into several different options just there and different locations. So, yeah, that's no problem.
As we know, one side of the building is park that not even a part of the park that people really use. So that would probably be. So, okay. See, are there
Jesse,
other-
were your
yeah.
questions answered then?
Yes, I mean, it sounds like there, and so just so I'm clear, you talked about maybe a couple turning radius. It seemed to me that it's a one-way flow of traffic.
Yes, sir.
And so how wide are you planning for that? And it just seems like, to me, it seems like you might be able to reduce that 56-foot dimension down a bit.
We could potentially, our thought was no matter what, we're going to be asking for the relief.
Sure.
If we can move it forward a little bit, that would certainly help. But,
As the applicant, you're supposed to, and we're only supposed to grant if, the variance is, is the applicant makes their case and all that,
Yeah.
the minimum relief necessary, right? So many of these changes you're talking about today do help to reduce the amount of relief that you need. And we're trying to just figure out whether there's a few more ways to help reduce the amount of relief. Because that's all we could give is the minimum amount.
And I think we could probably slide it up, maybe 4 or 5 feet. Because he wants to have drop off there.
Yeah.
You've got parking backing up.
Yeah, we got it.
and you've got cars coming through, so.
And if, I mean, even if it could be moved up 3 feet, then we could fit the 36-inch stairway in the back with the same amount of rear yard as we had originally proposed. So, that could possibly be, even at that number, would be a really good solution to continue with what we had
The original relief request.
originally relief requested, and still leave in areas for drop off, that you still have a turning radius, but if someone stops in front of the building, they're not gonna run into a car. I think we know how things are supposed to go and then how people actually use spaces, so we want to accommodate for that as well, because we know that there's no perfect world, especially.
And there, there will be tenants, not a ton of tenants, but that parking lot will be used by both the commercial space and for the guys that are trying to get down into the parking, so just wanted to give everyone a little bit of space so we're not dealing with any incidents in the parking lot.
Ed, do you have any questions?
Question I had that I didn't hear addressed is whether or not you analyzed where the floodplain line was.
So we have the stormwater management engineer who's going to testify.
Thank you.
And we have answers.
Yep, yes, sir.
Any other questions? Billy?
I don't have any more questions, and I thank you for many of the changes you made and the things that we've talked about, and your willingness to try to accommodate that.
And I echo that statement.
All right. Anything else from these guys?
I think that, as long as your questions are answered, we're good.
Thanks, Bruce. Thanks, Tom.
Thank you.
All right. What do we have next, Jen?
Why don't you come up, we have our stormwater guy.
All right, stormwater guy.
Hello.
Is that your trade name? Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and the capacity in which you appear?
Michael Fina. I represent FINA.
Wow, I butchered that one. Glad you asked. And what the capacity that you're appearing before the board tonight?
I'm a civil engineer, specialized in storm management. I work for Ambrick Technology.
Yeah, I'm sure you have some questions.
I do have
Hey, Jen?
just a couple of qualifying questions here.
Sure.
Can you tell us a little bit about your education, experience, background in this field?
Okay, I'm a licensed engineer in Pennsylvania for the past 15 years. And I have a BA degree in civil engineering from Drexel University.
And have you ever testified on zoning matters at this board or any other township boards?
Other townships, not this.
Okay. So with that, if you don't have any other questions, I would like to qualify him as an expert in engineering.
Do you have a CV on him, Jen? Just because we haven't.
I'm not sure, but I can email one to you.
Would you email it to Jonathan, please?
I will absolutely do that. We can
So,
take care of that.
Ed, do you have any questions
No questions.
before we accept them? Any concerns? You're our guy, so that's why I'm going to you.
Oh, not seen as,
Because I'm not sure what to ask.
no, there's nothing.
I do want to forward one point about moving the building back or forward.
First, we have to knock this. Jen's asked that you be admitted as an expert.
Okay.
And what's the narrow scope of his expertise that you want?
Should we do stormwater map? What is the most narrowest way we can qualify you as an expert?
I'm a stormwater specialist.
Okay. And Jesse, do you have any questions?
No question.
Billy?
No, your license is current, you're not subject to any
Correct.
suspension or revocation? Okay.
None.
No, I'm fine.
All right. So we'll accept him for this hearing as an expert in stormwater management.
And I will make sure that we end it.
Thank you.
All right, so you're familiar with the plans that have been submitted
Correct.
with this project and have reviewed them, correct?
Correct.
Okay. Can you
explain to us kind of the overall design strategy for water management of
Okay.
stormwater on this property?
So what I plan to do when we go into Saldo is a underground basin underneath the front parking lot where it will go and collect and manage and infiltrate the storm, the different storms, so that they meet all the township regulations.
And you were mentioning before, would moving the building up,
Would adversely affect the size of the basin that I could put underground.
and is there an amount that it could be moved up that wouldn't have?
I haven't done a formal study yet to go and say for sure how much or how little the building can move. That will have to be done during the design phase.
Well, to the extent it wouldn't comply with the township requirements on stormwater, I presume then it would come up in the variance stage. Okay, so I don't think, Jen, none of the plans that you've submitted tonight have any stormwater management facilities.
No.
But they will at our next meeting, is that?
So I believe the plan was to have a comprehensive like plan with the permits submitted, if the variances were approved. If there is some sort of level in between a full permit set, and what we have obviously, which is nothing showing, I think we can probably accommodate that request.
Well, how about this? Let's, Ed,
Go ahead.
go ahead.
No, I don't think there's a problem with that because it's a relatively flat lot, so the grades do come towards the front. You'll be able to get the water from the entire rooftop into the,
Easily.
yeah, that's what I thought, okay.
Okay, so if you did need a variance, you'll have to come back to us after Saldo.
Yes. We discussed that there's going to be, and I confirmed this with our client, that part of the roof is going to be a green roof. That green roof is not calculated in our impervious surface coverage because of our current township code. But can you explain how a green roof might have additional benefits in terms of managing the stormwater on this property, since we do have a large lot coverage?
Generally, green roof systems can help minimize the amount of water you need to infiltrate for the water quality storm, as well as the 2-year water recharge rules. So having that green roof means that's that much less water that needs to be routed and put underground because it will be managed on the roof through evaporation, transpiration, and a very slow release for any storms that are above a water quality storm.
Would it be a fair layperson description to say it would be like having a dry sponge in the sink that would prevent water from going down the drain? In very simple terms.
Generally, yes. I mean, you're putting 4 to 6 inches of soil on top of the roof. That soil will have grasses and sedums to soak up all that water and use it to thrive and grow.
Are there any other further questions about the green roof before I move on?
I'm just glad he mentioned 4 to 6 inches because I've seen green roofs that have just trays of.
I've done extensive amount of green roofs in Philadelphia, so I'm going to follow best practices that I've seen through there with this particular project. So an extensive green roof system should be no less than 4 inches deep. I've been told that that's the amount of soil you need for good root growth.
And you've already coordinated with the architects to make sure that the building can.
Not yet, but we will go and discuss those things. Because there would also be additional dead loads that the roof system would have to be able to handle. Things of that nature will be worked out.
Okay, so, in our previous, hearing, it was brought up that portions of this property might be in a 500-year floodplain.
There's potential that there's a 500-year floodplain. What I'd have to do is confer with a survey to see what the elevations are of the site and see if they are within or below that 500-year elevation.
And if there was a portion of the property, is it the whole property? Is it a corner of the property? Where would it be on the property that was causing this concern with from the neighbors?
It's a very small, almost like a little knife edge that goes into the front half of the property that looks like it's some kind of swale system was put in front of Route 3 that when the water elevation for a 500-year storm raises to would encroach up into that area.
Route 3 or?
Oh, sorry, it's Route 1?
Yeah.
I'm not that familiar with the area, so.
I just want a clear record, no
And
problem.
so is that an area that's like really close to the structure, or is it for, like, how far
It w-
away would this be from the structure?
If I were to guess, it would be right about where the parking lot is, where I would put my underground basin.
Okay.
It's only the 500 year, not the 100.
It's only the 500 years, so the township ordinances only ask me to measure up to the 100-year storm.
But, you know, if for any reason during the course of this project, those regulations change, we would still be meeting whatever the code.
I will be working very closely with the township engineer to go and get an approved set of designs, and everything will be meeting whatever rules the township has.
Well, before his retirement, it would have been this man approving any designs in the county. So
Okay.
that's why I defer to Ed on all things water, because I grew up in Overbrook, a green roof, and you painted it green. I don't know, you yuppies with this green roof.
It may make a difference on the 100 year because you wouldn't want to put an infiltration bed underneath a 100 year storm.
Right.
There's one.
And so I'm going to ask you the overall question as an expert here. Do you believe this project will increase dangers of flooding on the property or near the property, or overburden any sort of existing stormwater systems?
Not after I'm done with it.
And you don't think it'll cause flooding in any of the
Your
neighbors'
bill
properties?
just went
or
up,
anything like
brother,
that?
I'm sorry.
Absolutely not. The neighbors are all uphill.
Sorry.
Sorry, Arlene.
I asked if he, in his expert opinion, if he believed that this project would cause flooding to any of the neighbors' properties.
He's gonna make it with a 1,000-year storm.
And the answer is?
Not after I'm done with it.
All right. Those were my general questions that I had for him. If there's any other questions from the board.
Billy?
I have no other questions, thank you.
Jess?
I mean, the township engineer will probably say the same thing, but I would just say as an architect who's had aspirations for green roofs and then had to have them cut for budgetary reasons or structural reasons, you'll design the storm detention basin to meet the requirements without the green roof. Is that right? The green roof would be a
No, the
bonus.
green roof will be part of the stormwater strategy. So when we draft up the operation and maintenance agreement,
Right.
that green roof will be necessary.
Okay. And if it were to somehow be removed from the project, you would revise the
Then I would have to
design.
redesign the entire
Okay,
project.
got it. Okay. That's all I wanted to say. Thank you.
Ed, do you have any other questions?
No other questions?
All right. So that is my primary case. I know we discussed potential changes to the plan. I don't know where you guys are. I don't know where my client is with this.
How about we caucus for a moment and try to crystallize and ask Dan how we might go about suggesting or requesting some of the things that were mentioned here.
And-
So we'll take a 2-minute recess.
And then I just have a closing statement
Look
if
at-
you.
Okay. Jesse, you have a question?
Yeah, Mr. Chairman, I feel like one thing we did not address in all of the testimony was the issue of buffering requirements. And so I wanted to, looking at the most revised plans, again, referring to Exhibit M, and the site plan, there seems to be about a 5-foot area on each side yard Is there an ability to provide buffering that would screen the parking lot at the front? And I'll stay on that, and then I'll ask about the rear next.
So who's the best person to ask that question of, Jen?
Let's see here.
The space at the front right here.
Is
So
it,
let's talk about in front of the parking lot. It's been particularly here. We have 5 feet and 5 feet, or we have 5 feet and 4.6 feet on either side. Could there be some sort of like plantings or something like that that could buffer in that zone?
Absolutely. We haven't done landscaping plans currently. That was going to be a part of the CD set, but there's no issue with that. In
so
fact,
buffering's a requirement in the code, and we didn't address it for the hearing, and that's why we want to get it on the record, so.
Yes.
So yes,
To answer
you
the
would put
question.
in buffering.
In the portions where there's the parking lot, there can definitely be buffering in the proposed side yards.
Yeah.
Because you were asking for specific relief, and I just want to make sure whether or not you need the relief, or like the height, you've removed, earlier in testimony, you testified that you removed a story of the building, and you are no longer seeking the height relief, and I'm wondering if that is also true with some of the buffering.
So I think that the buffering, the problem is on like this lower portion, I believe 5 feet of buffering are needed, and we only have a 4-foot 6-inch side yard.
Which might be de minimis if we
So we could
talk
have,
to council.
we could put the buffering in that, all that 4 foot 6 inches, but we couldn't do the full 5 feet.
And then I'll change questioning to the rear. We discussed earlier whether or not there was an ability to reduce what you're asking for in the rear yard. And again, and now bringing buffering in, if you were able to move the building forward, and it might be good if we could walk away with a number, and if you want to, huddle briefly, that way you could also provide buffering in the rear to the residential neighborhoods where there was some concerns there.
Sure. I will add with the rear yard, it does back up to a portion of the residential lot that is separate from the portion that's developed and a landlocked second parcel that is just woods.
Understood.
So there is just buffering naturally there, but, to the extent we can move the building forward and put some sort of shrubbery back there, I don't think there's any sort of objection. Again, it probably wouldn't be the full 5 feet of buffering, but we could do something.
So I think so tying this with the other discussion about the stairwell in the back, or in the rear setback, and of course, the township does have an interest, in trying to ensure fire access to fight a fire in this building from the rear, right? So we typically would be looking for sort of 10 feet minimum vehicle space to get around the building. I realize some of the turning radiuses may be pretty tight, right? So, does it make sense that we try to think about what might be feasible, that if we were inclined to grant a variance, it would be a variance that, subject to a condition you could live with, about rear yard setback, where we're factoring staircase, which is of course sloping down from second floor to first floor, so it's not the whole thing. 10 feet of a vehicular and some amount of buffering, right? I realize that now we're talking quite a bit, and I'm just trying to figure out what can we all live with, right?
Yeah.
What could the applicant live with, and give us something to really think about whether we could grant that variance.
Okay.
Because right now it's so conceptual that it's hard for us to know whether the variance is the least amount of relief needed, and,
Sure. I mean, do you want to give us a brief moment to talk about this?
Sure.
And go off the record, and we'll go outside and we'll talk, and then we can come back and
but it's got to be.
All right, I'm going to call the next case just because
Sure.
we're running real low on time, so
Great.
as long as.
All right, let me move my
So
stuff then.
this case will be continued for a few minutes until we address these other two cases we have listed.
Thank you.
All right, so. Who's here for the township? One. Well, we need to talk. How much time do you think you need
Like 2 minutes.
to put on the whole case?
Yeah.
And are you guys here for Dayton? So, you've seen how long these things could drag out. Do you think it would be better for you guys to wait till the next hearing? Is there a reason you need to go tonight? We're technically supposed to stop at 11, but. Yeah,
we read what you submitted.
That's our case.
But the board may have questions. You guys okay with going a little past 11?
Yes.
Okay. All right, then let's see what we can do here. When they come back in, though, I have to switch back over to them. So we'll go. Our next case will be Z25-23, Haverford Township, owner of Meter Hall, 1682 Carricombe Drive, Haverford, PA, DC folio number 220800370000, to seek the following variance from the provisions of section 182-603C2D to permit the construction of a raised wood stage on concrete foundations where the use is not permitted. Property is zoned ROS, located in the 8th Ward. Good evening.
Hi,
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and the capacity in which you appear tonight?
Catherine Clifford, Katharine Clifford, and I am the president of the Haverford Township Historical Society.
Why don't you tell us, number one, do you have any exhibits that you want to submit?
Just what I submitted in the applications, which I was told was sent with all of you.
Okay, they're not part of the case unless they're individually marked as exhibits and identified for the record. So all that was submitted with your application.
Should have been a site plan showing the setback from the road as 20-something feet, and then should have been photos, but they might have been just for the historical commission.
Bill, help me with these.
Yeah, so,
I see three.
yeah, just three, right? A1, A2, A3?
So there's three documents attached to the application that seem to be unrelated to procedures.
Right, yeah, so we submitted both the historical commission
they don't just
application
get
and the
submitted, they have
zoning
to-
at the same time, so some might be for both.
They have to be individually marked as exhibits and then briefly described for the record. So
I don't
the-
know which ones you
the
have.
marking sequence will be A for applicant, A1, 2, and A3. And I can't do this for you, but I'm trying to help you along with it. So can you give us a brief description of what each depicts? So very briefly, what is A1?
A1 is the site plan of the location, proposed location of the stage, and it's, next to Carricombe Drive.
Ms. Clifford, would it be fair to describe it as the topographic plan that you see in the denominator in the
Yes,
lower
it's a
right corner?
topographic plan, so it shows the height of, topography.
And
A2 is a zoomed-in portion of that, with markings of the distance from the proposed stage to the edge of the road and the legal right-of-way. And then A3 is a plan of the actual stage, showing that it's concrete footers with a wood frame.
And you would like these entered into the record, right?
are there any other exhibits that you'd like to introduce and have marked and
No.
identified for the record? All right, and Bill.
Yeah, Ms. Clifford, I just want to make sure that we understand, you are the president of Haverford Township Historical Society. Are you appointed by the township
So
commission?
we
Is this
are the
Wait,
applicants.
let him ask his question
Oh,
first.
okay,
I understand you're the applicant.
okay.
I just want to understand that the relationship of the Historical Society. Are you a township committee or body?
No, we are a nonprofit entity that manages buildings that are owned by the township.
Okay,
So we run
and
the
so you do
programming.
that, you're by contract with the township?
We have a resolution that allows us to management of the buildings.
Okay. And is your board approve, or is it, are
None
your
of them
board
are
appointed by the township?
Nobody is appointed by the township.
And how, okay, so you are a completely independent body and your only relationship with the township is a contractual relationship in accordance with the resolution in place adopted by the commissioners?
Yes.
Is that, I think? Right, and you're authorized to speak on behalf of the Historical Society?
Yes.
And through your contractual relationship with the township, are you presenting this case also on behalf of the township?
I think the township, just because they're the owner of the land, it may be marked as the applicant, but we are the applicant because we are the ones that are going to be using it. But the township is also included because they're going to be the ones paying for it, so.
Okay. And within the scope of your engagement by the township, you have the authority to come before this board on behalf of the title owner of the land?
Yes.
The township, and submit this application, and you'd have the authority to not only present the case, but then discuss any alterations or anything?
Yes.
Okay. Do you have any?
No, I think you covered it, Bill. Thank you.
Jesse? Okay.
Okay, so now please tell us a little bit about, or as much as you would like to, about what you would like to do and why.
Okay. Every year, the Heritage Festival along Carricon Drive has live music, and every year we have a temporary stage that is put up by volunteers that takes a couple of days to put up and take down, and all of the volunteers are getting older, and all of the pieces are take up a lot of space, and so we would just like to have a permanent stage for both to have during the festival and also throughout the year. It'll be basically just a deck, and it'll we can put up a temporary covering when we need it. We have a tent structure that can come up and take down quickly, but we want the permanent base. It'll only be at most 18 inches off the ground, so you have the topographical map there, as you can see. So it'll be about 7 inches off the ground on one side and 18 inches in the front. And it's just a place for us to have year-round events.
You said you use live music during the Heritage Festival. What are the dates of the Heritage Festival?
It's
Typically,
only on the first Sunday in June.
first Sunday in June. Okay.
But this will allow us to use it year-round and have other groups be able to use it year-round.
Okay, so this would be an expansion of your live music use at Nider Hall from beyond the Heritage to 360, the other 364 days of the year?
Could be, but primarily, we were thinking of, how Kelly Music has, sometimes or the library has music in the parks and stuff like that. So this is all a township park. So it could be part of one of those programs.
What you said I would assume the Historical Society has been thinking about how you would use it more. Have you guys thought what a reasonable amount of how many days it would actually be used?
It wouldn't be used every single day.
Okay, but
we haven't gotten that far because haven't gotten it approved yet. But it would be available to any because it would be within the township park. It would be available to any township entity that would want to use it.
Okay. And you, you had asked, I think you had testified that you are applying for both variances here and approval from the Historic Commission?
No, we already got approval from the Historical Commission. We're just asking for the variance because it's in the the ROS zone, and so it needs to be, which has a 75-foot setback, which would put it into the trees. So we're asking for a variance for the technically front yard setback, even though neither of the buildings have a front yard. So.
Yeah, so the, let's see. So did the Historic Commission, you didn't submit their approval. Did they give you an approval in writing?
Jonathan should have it. It was sent to.
Is there an Historic Commission approval for this that you have of record? And should it be admitted as a,
It was approved in April.
I don't have any official record of the application going before the Historic Commission.
okay, so if we get to, I think we'd like to see it because, do you remember the terms and conditions of that approval, or were there any conditions on the approval?
Just that it would be wood.
It would be wood.
Like they had no problem
And
with it.
they reviewed exhibits A1, A2, A3?
The one with the setback was not submitted as part of that one because that's only your purview, but they saw pictures of the site and examples of, we told them what kind of materials we wanted. Be like mahogany or ipe.
And they didn't have any limitations on the frequency of use or the time of use?
No.
Or no? Okay. I would like to see that if we can get it. All right, I'm sorry. So hours of operation generally and for
The
this
festival
stage itself?
The festival is from 11 till 4. Beyond that, that would be up to the township Parks and Rec to permit whatever they feel is necessary.
Okay. And I'm curious, I'm generally aware of that area, but the closest residence, have you figured out? I mean, we can't see that from yours.
No, the closest residence might be either across the creek or across the train tracks. There are no residents along Carricung Drive. It is bounded on the one side by the high-speed line and the other side by the Cubs Creek.
Cubs Creek, okay.
And then the people on the other side of Cubs Creek have really large rear yards, so the houses are pretty far away.
And then you heard some discussions in a prior case about noise levels. Are you going to be using electronic amplification of instruments?
Yes, during the festival we do, yeah.
And have you any reason to think that you would struggle to comply with the township code on the maximum decibel level?
I don't, like, we've never had, in fact, like, we've had years where it's been too quiet for people to hear, so.
Okay.
So,
Are you, in the stage itself, are you building any fixed electrical systems?
We're hoping to have just an outlet that the, like, speakers can plug into, but we're not having, like, permanent speakers or anything.
This would just be a regular 110, 120 volt outlet?
Yeah, whatever the
A regular household outlet?
Whatever the township electrician will allow us to have there. Yeah, to put up the.
Okay, I'll take this one. Okay, I'm sorry. I just wanted to ask you, as you were about to move off of the stage, I think, and talk about something else as part of your application?
No, the stage is the only part of this application.
Yeah, okay.
I don't.
Anything else you want to share?
We want to build this with volunteer labor, and we need to build this in the fall. So I would really hope that we can get this approved soon, before the ground freezes.
Okay. Jesse, any questions?
The only question I was going to ask, and you've answered it by the Historic Commission's ruling, was that whether you considered doing this as just a slab, like a concrete slab, or pavers that
So
where
that
you.
was the first. That was the first thing that we wanted to do, but the Historical Commission did not want a concrete slab.
Okay,
So
so
they required it to be wood.
okay, it's my understanding that you would not. I don't even think you would need to be here if you were able to build a slab. So the reason that you're here is mainly because the Historic Commission required you to do it in wood.
No, we are here because of the setback.
But if it was, and Jonathan, correct me if
Even
I'm
if it
wrong,
was-
but if it wasn't a structure, if it was just a patio, would there be any requirement for a setback variance?
Still is a patio. It would be an 18-inch high slab.
A paver patio generally isn't allowed in the front yard for residential use, but there would be no setback requirement for a paver patio in this particular situation.
This is a wood patio. It's a deck, patio. I mean,
nonetheless-
We very definitely make a distinction between a raised deck, wood deck, and a, patio that's a paver patio that's like in the ground. One is actually defined as a structure, the other is not, and that's where the definition comes
okay.
in.
Well,
So-
this would have been a raised, like regardless of what it's made out of, it would have been raised up, so it's not just like a flat patio in your backyard, like because we need the height for the stage.
Strangely enough, our definition says one's a structure and the other is not.
Okay, well,
That was
I
my
was told that I had to go in front of both you and the historical commission.
that was my only
Regardless
question.
of whatever, and the
So-
historical commission needed it to be wood.
So just to be, make sure it's clear on the record, the maximum height of the top of the wood deck that you're building here is 18 inches off the median of the ground is flat, the ground is sloping?
The ground is slightly sloping,
So
so
what's
the
the
highest
highest?
point would be 18 inches,
And the lowest point?
maybe about 7 inches. It has to be like figured out on site with, whoever's doing the
And
footings.
there was no way to build your pilings, presumably on the lower sloped part, so you'd have a level thing, and just have a stage that you could disassemble and leave your footings, but just leave only the footings and drop the posts into them?
That would be a lot of footings and be like more of a hazard for any like kids and stuff because like the road is closed on Sundays and there's a lot of people like walking and biking and stuff like that, and that would just be, a hazard that we don't want to deal with.
And how many borings or posts into the ground does this involve?
It's on there, I think it's like every
Right, I'm
maybe
just trying
20
to.
or something. 15? Yeah.
15, okay. And just to confirm, the overall dimensions we're talking about is
16 by 20.
20 feet wide by 6 feet deep?
16, yeah.
Okay, yeah, it's just, okay. Is your show
I
6?
thought the same thing. It's
Okay,
16.
it's just a bad photocopy. Okay, I got it. Okay, so 20 by 16, requiring 15 posts or columns.
Yeah.
Okay. Jesse, any other questions?
No other questions.
Ed?
Yes, the questions I have is, have you determined whether or not it's in the floodplain?
Yes. It is not. There was a chance that it was, but once we got back the topographical thing, the engineer said it was not. So there are other parts of the parking lot which are, but not this area.
I'm a little confused about what the stage is right by the parking lot. I know your big event day, you probably don't use that parking lot because road's closed.
Right. During that day, we do not use that parking lot for parking. We use it for everything else, though. So we have the beer tent, the gift shop, the info tent, and the places for people to sit and watch the music.
I'm confused with what the stage, where other events where the audience would be.
Where the audience would be. Well, people, like we use, like for that event, we have grass parking lots, the Manoa Road side and the Beechwood train station side, and people just walk down with the road closed. So if the road's closed on Sunday, people just walk down anyway.
I understand that, but you're talking about opening it up for people to use for different events.
Yeah.
Like, they do this across the street from my house in Normandy Park, and it's not a problem. But here, your parking is the only thing you have. Why would you take up the parking?
It's literally just 2 spots, possibly. It's not even like a spot, because it's all, it's like grass and gravel, and there's like a bench there, so nobody parks in that spot anyway. So we're not really taking up any spotting.
You don't have
It's a gravel lot. There's another gravel lot further down, down Karakung. And then like when we have our events like Oktoberfest, people just find places to park, or they Uber, or they walk.
Gotcha. And then, I don't know how big this park is, but you contend that there's no place to put this stage other than in its front yard. but we don't have anything to show that. Why is there no other place on the property that could be accommodating for the stage?
Well, this is this is the largest flat space that we have. And this is where we've always had the music acts on the large stage. And if we were to put it anywhere else, you're dealing with, we have relatively steep slopes closer to the buildings. We have a creek on the other side of Carracone Road, so there's no space on that side of the road. And then on the other side of the parking lot, there's grass and steep slopes up to a train line, so there's really no place to put this. Farther to the east, south, there's floodplains issues and stuff like that. So this is the only place to put any kind of raised structure.
Okay, no other questions. Thank you.
Okay. So you say you want this to be available to people to use 365 days a year, is that correct?
Maybe not 365
But
days
what-
a year,
whatever,
but yeah,
weather
I mean,
permitting.
that would be up to the township permit.
So who's going to control?
Township, like Parks and Rec would permit that.
So it would be available only by permit?
I mean, like we have to get a permit to do our event. So yeah, I would imagine.
Well, that's very important to me, and I need a definitive answer on that, because we can't just have kids that form a band up there and start playing, and it's got to be subject to the same time restrictions. But how about if we I'm going to pause this, call the last case. They're going to continue to the next hearing, and then we'll resume this, we'll wrap it up, and then we'll wrap Jen up, okay? So I'm sorry, I'm just going to ask you to step aside for one moment. That case is continued for 15 minutes. Next case, Z2528, Daniel Hatfield, owner of 634 Dayton Bryn Mawr, PA, DC parcel number 220500248000, who seeks a special exception from section 182-802B1 to allow the extension of a non-conforming use being a deck on the rear of the existing townhouse residence, a type not permitted by right, a special exception or conditional use, making it a pre-existing non-conforming use, a variance from section 182-802B12, and slow me down if you want to, Arlene, limiting the expansion of a pre-existing non-conforming use by special exception to 50%, a variance from section 208C2D to allow the maximum building coverage of 59.4% where 45% is permitted, and the existing 53.2%. A variance from section 182C2F3 to allow a minimum of 0-foot setback where 15 foot each is required, and a variance from section 182-208C2G to allow a deck in the rear yard setback, which would reduce the existing from 15 feet to 9 feet, where 25 foot is required. The property zone R6 and located in the 5th Ward. I just need your name real quickly for the record.
This is Daniel Hatfield,
applicant.
the applicant.
You're Dan, come on up.
Hello, my name is Daniel Hatfield.
I'll swear you real quickly. Dan, please raise your right hand. Do you swear to tell the truth, all the truth, and nothing but the truth, so help you God?
I do.
And your full name and address for the record?
Daniel Hatfield, 634 Dayton Road.
Okay. And you've sat here throughout the night. It's 11 o'clock. We apologize. But you would like us to continue your case to the next regularly scheduled meeting, right?
Yes, please.
What's our meeting date?
If it's 2 weeks, it's September 4th. 2 weeks.
So we're on for the 4th? Okay. And can we list this first that night? Sure.
Would be great.
Well, whether we do or we don't, I'll call it out of order. So this case is continued to our September 4th hearing.
Do you need to have him sworn in? He's my next time.
Oh, good.
Thank
Yeah.
you.
And look, you got some insight into how it might go and the details you need to bring and the exhibits and everything.
We'll make
So
sure to be fully prepped.
hopefully it was some benefit.
Thank you.
We'll resume case Z25-23, Haverford Township, and I won't read the rest of the case description into the record. Okay. Where did we leave off?
We were talking about the township permitting process, and that any events here would be subject to township Parks and Rec permitting, and no.
Or whoever's responsible for it, I mean,
Or
I don't,
whoever the township, but this is not something the Historical Society actually grants permission to use.
No, I mean, like, it would be a township facility for them to figure out. if they
Jonathan,
want.
do you have any insight into who might be responsible for permitting? I think I need a clear answer on that before I can vote on this. And there are other questions that I think, at a time when the board has more time to give more consideration to this, that the board will have. So,
What other questions do you have?
And we also wanted a
need?
copy of the Historic Commission's findings.
Right.
I was under the impression that that would have been given to you.
Yeah,
months
wasn't-
ago.
nothing is given to us unless you give it to us. None of us work-
I was
we
not
don't work for the
told that I
township.
have to bring anything or do anything to give to you. I gave everything to the township
Okay.
months ago and was told that you guys see this beforehand, so I apologize for not bringing
It's
these
okay.
things. I never received the copy of the Historical Commission report either. But Jamie Jelosian has it.
Maybe,
so.
yeah, so, okay.
And the
Yeah.
permitting, I mean, a real finite answer on who's responsible for controlling the site and permitting.
Besides the permitting, do you have any issues with the setback?
I have some concerns that we have a question of hardship here. The township maintains lots of parks. Why we need to turn a very sensitive historic resource site, park, into a potentially highly used site for live music events when it could go on in any one of the parks around here. Why do we need, I'm not sure why. So it would be, and you don't have, you can explain now if you want, but you can also, when we do come back, if you get more insights into that, you're welcome to supplement whatever you say now.
Okay, we are asking for it primarily for the Heritage Festival event because all of our volunteers are getting older and there's like only 2 people that know how to put the stage together, and both of them have basically said they want to stop putting it together. So we have no real options for.
But can't the
for that.
township just pay someone if it's one day a year? I'm just
No,
asking the
we
obvious
pay
question.
we pay to put the thing together. So like this is more cost effective to put in a permanent stage than to rent a stage every single year. Those could be thousands and thousands of dollars.
So do you charge for these events?
We ask for a donation.
Okay, so it's voluntary, so the event's a fundraiser for you.
Yes.
And do you anticipate that the other events that would be a fundraiser for you too?
I don't know. Like we haven't discussed, but like we could use it for, author talks or something like that, like something historical as well. There's no. We primarily need it for the Heritage Festival, and then we're like, well, if it's going to be up all year round, we could offer it to other groups, and the township can figure that out.
As stewards of this historic resource for the township, do you have any concerns about overuse of the site because of
We want
live
people to
music
use
events?
the site. Like
That's not. I said just concerns about overuse.
Yeah.
In other words, you haven't suggested that there's any amount of frequency of events that would give you pause. You said it's probably not 365 days
Well,
a
it's
year. I get it.
definitely not going to be 365
Okay.
days. It's very unlikely that would be weekly either.
Right.
It would probably be like 3 or 4 times a year, at most.
Okay. I guess if she would accept that as a condition, if that.
Well, let's see what the permitting process is, but if, as the stewards, if you have any, I'm interested in what your say is. So in other words, if you said, well, we're really not comfortable at some point that there are too many events, whether it's 3 or 4, or whether it's 30 or 40, at some point, if you thought there was too much wear and tear for Nider Hall and its grounds, the township, in theory, could just keep issuing permits. And at what point do you have any say as the steward of this site for the township to say, no, too much?
Probably, yes. I mean, but we're controlling like the buildings and we have, like gardeners that work on the grounds. But, you know, like if there's something going on in the parking lot and we have nothing to do with it, then like the buildings won't be open, the bathrooms won't be available, you know, so that like anyone who wants to have a permit there to have an event would have to arrange for their own like porta potties and like other things like that. So we do that for our festival. And if it's something that we put on, then, you know, we can have the buildings open.
All right, well, you have a sense of the kind of thoughts and questions that arose in our minds. So give it some thought on your end. And when we reconvene on September 4th, we'll finalize this and you'll be second. I promised those people that would be first.
All right.
Okay, so with that, we'll continue this case to our September 4th hearing.
Okay, thank you.
All right, you're welcome. Jen, welcome back.
All right. Oh, and there's my pen. I left it
We'll,
up here.
we'll continue with case E25-20. All right, so you talk.
So we talked, and there is an agreement that we can move the building up another 5 feet for a total rear yard of 11 feet, understanding that the staircase would still be in that 11 feet. We would also stipulate that it'll be an open staircase and can have open treads. And so it'll have a minimum impact on access to the ground floor, you know, firefighting space. So I think we would have a total rear yard of 11 feet and then, you know, a little portion where we might have some encroachment of the stair, but the stairway would be open and, you know, not an enclosed staircase that might impede access underneath the staircase, if that makes sense. Happy to do the buffering on the side by the parking lot. I will note that the one side is the parkland and not residential use, and the other side of the property is zoned residential but used as a dentist's office. So, you know, and I understand that it's zoned residential and could become a house, so we're happy to provide that buffering, but I just wanted to note that for the record, that it's not currently used residentially.
So you wouldn't be putting buffering on the park side, but you would be willing to put some buffering on the side?
We can put it on both sides.
Okay.
We can put it on both sides. I'm just noting for the record that there's not a residential use on either
The normal
side.
benefit that one would get from buffering, I mean, between two commercial.
We're putting buffering between two parking lots essentially, so, but happy to do that because I think it makes the project look nicer.
And so you wouldn't even propose like a 2-foot strip of buffering on the back side?
I mean, I think we have right there, I mean, I don't know what the higher concern is. We can have 11 feet back there, and I don't know if the higher concern is to put buffering in against essentially a forested area or provide for more safety firefighting area. I'm happy to divide it up as necessary, but I thought that the general feeling might be to leave it open, have more area in the back, and especially because that's a forested area that's probably going to remain forested. I believe there was testimony from the owner that it's rather swampy and unusable.
Okay. Got it. Thank you.
Okay.
All right, well,
And with
what's
that,
left?
I just had a brief, I'm going to try to keep this really brief, but since we've gone over numerous things throughout the different things, give me 2 or 3 minutes here. We have an existing vacant parcel, and we are proposing a new 2-story mixed-use development with a basketball training facility on the lower floor and 6 rental units above. We're providing more than required parking, including the underground parking spaces. We have a location on a busy road, on Township Line Road, in what is a mixed-use area. We have a park, we have dentists, we have some landlocked residential parcels to the back, the golf course, and when you go further out, we have mixes of commercial uses, office buildings, railroad tracks, shopping centers. We really have a mixed use in this area. And the property is zoned currently for single-family use. We put on some testimony about that it has been marketed for use as a single family and development, and there's been no takers. There's been some people who have looked at some, you know, multifamily use, but not a single family use. And so, you know, when we're going to say then, hey, we got to look at what might be an appropriate use, we're again looking at what's around this property, which I've already described. As some further guidance, I know we talked about the comprehensive plan and the desire of the township to, you know, diversify our housing stock and encourage mixes of uses that are compatible with transit. I know we have transit issues, but we are not in a line that is being proposed to have significant cuts. So that line could actually become much more important as we move forward, with people being able to have access to public transit into the city from their living space. And so I also, you know, part of that comprehensive plan is you know, making the township more green. We're proposing the green roof, something that's encouraged in that comprehensive plan. We're also helping the transportation goals by, again, creating some mixed use, mix of use and different types of housing stock along public transit lines that will hopefully still be there and are proposed to still be there right now. And it is also within walking distance to those shopping centers that are in Philadelphia that have grocery stores and all sorts of other amenities, restaurants, that sort of thing. So this is exactly the type of lot where the township can move some of those goals forward. While it is not particularly identified, that is just a suggestion in the comprehensive plan, and in previous comprehensive plans it was. But I think that it suits that goal, this parcel, especially if we're based on the fact that we've kind of demonstrated that the single family use might not be the appropriate zoning. So we know we have a fairly long list of variances that we still need. I hope that we've demonstrated that we've really been trying to narrow those down to what's really, really essential and the minimum necessary in order to have a viable use of this property for something that's going to get built and be used and, you know, be an asset to the community. There are unique conditions here based on the size of the lot, the location of the lot, the dimensions, what's surrounding it. So I think that, you know, based on that, we meet the requirements for the variances. And again, we're developing something that's in the character of the neighborhood, in the mixed use on this busy road. And I don't think, especially with the reduction of the height and reduction of the units, and, you know, accommodating some of the other parking needs and things like that, we're really not altering the character of the neighborhood or in any way, you know, causing harm to the near neighbors. So with that, I would ask that, you know, based on our revised plans and, sorry about that, the revised plans and our commentary about, you know, moving some stairways, moving the building up, that you would grant our requested variances.
Jen, I have one question for
Sure.
you, and it's just something that sticks in my mind. So how do we protect against if Mustafa was to sell the property and someone else wants to come in there and they have a full-size basketball court, right? Now, he's only going to have 3 people, that's what the testimony I think was,
Sure.
there at any given time to use the court, because he's going to do specialized training and everything. So if he ever sold it and a subsequent owner comes in and says, well, I have this full court, basketball court inside, you know, and I want to use it for A, B, and C, which requires much more parking and makes the site much more heavily used. I mean, how do we guard against that? The variances would go with the land, right?
Sure.
But someone would come in.
And I think that we need to probably put some restrictions on it. I agree. And if we think about restrictions, you know, that it can't be used for any tournaments or larger competition events. And that's going to limit and you could possibly even limit the number of occupants. You know, because when I've done event spaces before, work with clients, it's like, you know, technically you can fit 100 people in this space, but the community only wants 30-person events. And so, you know, if there's a reasonable number based on the parking, like maybe no more than 10 people being trained at one time, I think that we could reasonably limit, you know, that use going forward if the building sold through things like that, like, you know, eliminating tournaments, eliminating competitions. You know, maybe 10 is a fair number, considering, you know, that we have some extra parking spaces. I haven't talked about that number, but I think if we could come up with a reasonable number of people that can be trained at the facility at any given time, that maybe it would, you know, another owner might have a small group instead of one-on-one, but we're not talking about large camps, we're not talking about events, we're not talking about that.
So
And
limit the occupancy.
Yeah, I think that would be a really, I think that is the way that you prevent, you know, and if someone then wanted to do something else, they would have to come before the board again when they bought the property.
And as previously testified, there's no plans for spectator seating, right? There's not even room for spectator seating.
No.
Right, okay.
So that could be another condition.
Yeah.
If it were approved.
Yeah, exactly, that there would be no spectator seating. I believe there might be like a bench or something like that there if someone needs to sit down during practice, but like
That's
no stadium seating, you know. I would like there to be a chair for people to sit on, but, you know, not,
For participant, for.
yeah, only seating for participants and training or whatever, that sort of thing.
No. And I have no clue what the outcome might be, but we really do appreciate his willingness and Bruce's efforts and everyone's efforts to minimize the request, the requested relief, very much.
All right, thank you so much.
So thank you.
We're trying.
So are we done then? No other questions? Ed, Billy?
No, thank
you. Jess? And anything else you'd like to add?
I think that is it.
All right.
I assume you need time to review this one.
Oh, yeah. You think? I may actually need to, yeah. Did you admit were your exhibits? I'll admit. You just moved to the admission of your exhibits, and I think.
Oh, yes, I would move to enter, I think I moved to enter the other ones, but my exhibit M, let's move that one in.
M and all the others.
And all the others.
I thought
Just
we
in case.
admitted the others, but just in case, so the exhibits
We'll be
are all
sure.
admitted. No other questions, right? Are we going to be able to do a decision on this on September 5th? Anybody need the transcript or anything? Yeah, we're going to need the transcript. How is this?
16th be okay? Or the 18th? What is the 18th? 18th?
Be the 19th, right?
So would a
The
vote on
later
the
September
18th
one,
be
yes.
enough so that Jessica could get a chance to catch up on the 18th?
September. We are good.
Right, so we're going to schedule this for, and Arlene, does that work for you? Okay. So,
And I will email you the CV that I owe you. I will email Jonathan that.
so with that, we'll close the record on this case and the decision will be rendered at our September 18th hearing.
All right, wonderful, thank you so much, and I hope
Sure,
everyone
off
comes
the
up.
record. Would you represent, that's the historical commission people? Yeah, I know. Any other administrative matters, any minutes? With that, we are adjourned.